Maybe it's a lordship.
Yes,
With due consider the other chair lordship, I beg to mention item number 34 lordship. Lordship, kindly adjourn the matter for 2 weeks lordship. I have some personal difficulties on today.
you are for the,
I am for the petitioner lordship.
okay. That's paid for by the Learned Council for the petitioner. Matter stands adjourned for 2 weeks. Item 34.
30. Obliged. May I please, ma'am?
Yes.
My lord, item number 13, my lord, my learned friend is also there. She is caveator in this case, my lord. Today, my learned senior counsel, M.K. Sudri is suffering from TEGOR, so it will not be able to. So can it be fixed up? So
My lord, the
19,
caveator in the instant case has also filed an affidavit praying for a direction for implementation of order impugned in the instant writ petition. That matter is fixed on 21. So may I pray that both the matter may come up for consideration on
That-
21st, my lord.
Yes, in that case, my lord, what my learned.
In
friend
my
is-
case, notice has already been
Notice is
issued.
issued. Here, this is motion. So that's why I.
Same matter, similar matter, my lord, the identical matters, my lord, subject matter is identical. In my matter, I am praying for a direction for implementation of the
I'm
impugned order.
praying for, I'm
And he is
challenging.
praying for
the-
setting aside that order, my lord. He is for our college authority, my lord. This
So-
writ petition has been filed by the chairman, governing body and a principal. The 21st, my lord,
So how does it come together? How can it come together in motion column?
my lord, our matter is fixed on 21, my lord.
Already
sir.
fixed, isn't it?
Yes.
Yes, no, it is already,
So we'll list it on 21.
my lord,
On that day, we take it up together,
my lord.
Yes.
no matter where. Okay, as paid for by Mr. J. Payang and not objected to by the Learned Council for the opposite party. He lays this matter on 21st of January 2026.
7182 of 2025, my lord.
Along.
So that is already fixed.
Yes, my lord.
On that day, you just make a
My lord,
mention, these two.
and the
together,
problem.
take up together.
My lord, may I pray for mention my item number 4, my lord.
Yes,
In this matter relates to my lord dismissal from service. And petitioner had preferred an appeal before the authorities. And the Board of Governors had taken up the matter in last December, my lord, last week of December. Now the matter is pending before the president of the CIT, Kokrajhar. And as per my instruction, my lord, he is going to take a decision, my lord, within a week. So may I pray that the matter may come up after 2 weeks or 3 weeks, my lord?
as paid for by the Learned Council for the petitioner, that this matter will listed again after 2 weeks.
My
2 weeks.
2 weeks, my lord. Deep law.
May I pray for listing of a writ petition for withdrawal, my lord?
Yes.
Day after tomorrow.
All right.
May it please your lordship. My lord, may I pray for listing of 2 IAs for withdrawal, my lord, tomorrow, my lord. Oblige.
May I please, Your Worship? I beg to mention for listing of a writ petition for motion before 10th, that is tomorrow or day after tomorrow.
What is the urgency?
Urgency, my senior won't be here from 10th to 13th, so after 13 also it is possible. Your Worship.
That is not an urgency thing. When he comes and because of his inconvenience, we cannot adjourn the matter like that. I mean, we
Okay.
cannot
If you list the matter after 13, that is 14, 15,
Hmm? Motion,
motion,
give a date then. 19th.
19. Plus.
May I please, your lordship? Lordship, I beg to mention item number 19. Lordship, as my senior is suffering from some illness, lordship, kindly adjourn the matter after a week.
Item 19
19, lordship.
for the petitioner.
Yes, lordship.
Okay, counsel for the petitioner is said to be indisposed. As prayed for, matter stands adjourned for a week.
Master, please.
I, on behalf of N. Hussain, item number 2 and 3. Let it come after vacation immediately.
On behalf of,
N. Hussain,
why,
some difficulty, my lord, to that. And then
on the
item
prayer made on behalf of Mr. N. Hussain, learned counsel for the petitioner, matter stands adjourned for a week. 2 and 3.
that may be fixed. My lord. 2 and 3. 2 and 3.
List again on 22/1, 26.
May I please, similar pay item number 5. I pay for possible for the day. 5.
As paid for by the learned counsel of petitioner, matter stands passed over for the day.
After 22 days.
Passed over already.
Lordship, deep levels.
My lord, matter is fixed today for regarding maintain immunity of the petition,
Ah, correct.
section 20
Right.
of the Contempt of Court Act. On that question, I want to rely upon, I cite a decision of this court, my lord, DB decision. reported on 2008 to GLR 158. There I rely on paragraph 8. I say. Is there,
GLR,
GLR. Huh? Oh, I'm sorry, GLJ.
GLJ.
GLJ. I'm sorry, Milord. GLJ 208, volume 2, 158. Thought,
Yes. Please read it slowly.
Uh.
Copy is not available till now. Did you provide the citation?
yes, we have provided in the morning.
Just read it.
From the aforesaid provision of section 20 of the Contempt of Court Act, a reasonable man can easily come to the conclusion that the legislature, by way of enacting the said provision, prescribed a period of limitation of initiating a proceeding under the said act, or in other words, put certain restrictions on the court for taking action for contempt after a period of limitation prescribed. As the said provision of section 20 of the Contempt of Court Act is a mandatory one, it would not be proper for the court to frustrate the legislative mandate. Undoubtedly, the High Court is not powerless. Even when the period of 1 year is expired from the date of alleged violation of the Contempt Court's order, court can exercise its inherent power under Article 215 of the Constitution, but this case is not such one. So it said that 215 can be exercised.
It said it can be exercised, but that this case is not one such case where such power can be exercised.
No, that on the facts it was different. On the facts, Milord,
Correct. See, from what you have read and from what I've understood
Hmm.
is that legislature has, in its own wisdom, enacted the act providing section 20 prescribing limitation of 1 year.
no,
So this thing should not be frustrated.
it would go.
Nevertheless, the High Court is not powerless. It can always exercise that powers under Article 215.
215, yes.
But this is not one such case where such kind of power should be exercised. That's what they say. So ultimately, it was not exercised. So if you want to rely upon that judgment, you will have
Next I will cite Milord.
no, you
to
will have
the-
to convince the court that this is one such case where 215 should be exercised. Although 20 has there,
Because in this case, Milord, specific direction was given for holding of the SIT within a certain period. But during that period, they have not done it, nor within that year. For that, Milord, they said we will hold it, we will hold it. That way,
in your case, in this case,
in my case, Milord, in my case, direction was for holding of the SIT. Then
we'll do one thing,
some-
Mr. Chalia.
Yes.
We'll issue notice, but I'll leave that question open
my lord,
for
my
argument
my
at a
lord.
subsequent stage.
I will rely on also 144 SCC
Sorry,
573.
please
It is
repeat,
SCC.
please
I think
repeat,
that is there.
please repeat.
Paragraph 9. The
No.
contempt of court is a special jurisdiction to be exercised sparingly and with caution whenever an act adversely affects the administration of justice or which tends to impede its course or tends to shake the public confidence in the judicial institutions. This jurisdiction may also be exercised when the act complaint of adversely affects the majesty of law or dignity of the courts. The purpose of contempt jurisdiction is to uphold the majesty and dignity of the court of law. And then bars refers
Which
also
paragraph?
referred to.
Which paragraph?
9 and 10 below. Paragraph 9 and 10. They refer to the Supreme Court Bar Association case also in that matter. And then ten may also be relevant.
But how is relevant, how this case is relevant to your case? This speaks about the exercise of the jurisdiction of be sparingly done. How does it help
But-
your
but-
case?
It says that it should be contemplated of adversely affecting the majesty of the law of. Here in this case, in my present case, my lord, the direction was given, specific direction for holding. And the authority administration has not done that.
No, that is one thing. What we were on was regarding the delay.
That's true, my lord. That's.
This is not on delay. This is upholding the majesty of the court. Delay was regarding GL, that GLJ citation.
Yes.
Anyway, I'll issue notice, but I'll leave it open. All right,
But
will not,
in the other way also, majesty of the court is delay. Otherwise also, when majesty of the court is affected, when it is not denied, when it is not affected.
no, you
They
come
will not
after,
comply with.
2 or 3 years and you say majesty of court is affected. Can it be accepted? You have to come in within that time frame,
That's true. But
1 year, as per section 20.
that's-
Although GLJ says that the power of the court under 215 is not
215 is
affected,
there, my lord.
is there.
There are other single judges decision also, but where it say that 215 does not bar that delay matter. Because that is a specific direction under the constitution that will be denied.
No, anyway, I can take a decision today itself. But perhaps I'll issue notice with that,
My lord, that.
leaving it open,
That.
since
that
that
can be
judgment is
kept
not with
open.
me.
Yes,
I heard Mr. GP Chaliha, Learned Senior Counsel, assisted by Ms. M. Roy for the petitioners, who submits that the order of this court dated 10/8/2023, passed in WPC number 2227 of 2020, has not been complied with by the respondents, despite the copy of the same having been furnished to them. Now, when the matter was listed on 19/12/2025, this court observed that since the contempt petition has been filed beyond the period of limitation prescribed by section 20 of the Contempt of Courts Act 1971. In filing the instant contempt petition. So today, Mr. DP Chaliha, Learned Senior Counsel, submits that the High Court has the jurisdiction to entertain the contempt petition in view of the powers conferred by Article 215 of the Constitution of India. Even if Section 20 of the Contempt of Courts Act 1971 is said to be attracted. Stop in support of his submission. He relies upon the relies upon a decision of a division bench of this court rendered in name of the party, GLJ.
Yes. All Manipur aided elementary school and unapproved teachers association.
All
Manipur
all
aided
Manipur aided
elementary schools
elementary schools,
unapproved teachers association.
unapproved
Approved teachers association.
unapproved teachers association versus
Versus the state versus Henry K. Henny and others.
versus Henrique Henny.
Henny, H-E-N-I.
It is
And
given in
others.
writing. Mr. Roy, you give in writing to the PS.
My lord.
Reported in 2008, volume 2, GLJ 158.
158.
Mr. Learned Senior Counsel further submits that the contempt jurisdiction can be invoked when the act complained of adversely affects the majesty of law or dignity of courts. Stop. In this regard, he relies upon the case of Dr. Pradeep Kumar Biswas versus Subrata Das and others, reported in 2004, 4 SCC 573. Next para, in view of above, issue notice returnable by 4 weeks. Steps within 3 days by speed post. The maintainability of the contempt petition is left open to be considered at an appropriate time. List again after 4 weeks. Yes.
My lord, matter pertains to compassionate appointment, lordship. What's the item number, lordship, 42, 43 and 44. All the matters are of similar issue, lordship. As per the last order, lordship, these matters also directed to be listed along with lordship.
42,
Lordship,
42 to 44,
42, 43 and 44, lordship.
along with what? Along with item
Along
6,
with item number, lordship, 6 and 7, lordship.
6 and 7.
6 and 7, lordship.
What is the similarity?
Similarity, lordship, all the petitioners are challenging one speaking order passed by the Deputy Commissioner of Dhemaji, lordship.
Show me page number.
Oh, lordship. Item number 6, lordship.
Order dated 30/12/2022.
Yes, my lord. 13/12/2022, lordship.
What is that order about? Page number?
Piece number, lordship, 29, lordship. Page number 29. 29, serial number 26, lordship. Is here, lordship, as per the speaking order, his date of application was recorded as 31/10/2022. Whereas he submitted application lordship on 8/5/2011 lordship. On last occasion lordship, my learned friend was directed to bring instruction lordship in this matter lordship.
He submitted application on 8/5/2011.
Yes, my lord. Yes, he 8/5/2011 lordship, page 19 lordship. That application was not considered lordship. That application was yet to be placed lordship.
And instead, it says that application date is 31/10/2022.
22. My lord, it
So-
was the wrong date of submission of application lordship.
Okay, so what is the common issue with regard to the other items?
Here, Lordship, all the petitioners are challenging this speaking order, Lordship. Their names also included in this speaking order, Lordship.
Okay, and the ground for challenge is that wrong.
Wrong date
indication-
of submission of application, Lordship.
Okay,
Original application was not placed before the DLC, Lordship.
so why is it
Lordship-
listed today for instruction?
Instruction, Lordship. And so far, my instruction, Lordship, there it is, their processing, Lordship. It's under process, Lordship.
Mr. Diori, any instruction? You want me to read this?
No, no, your lordship, what I want
tell
to
me.
submit is that, your lordship, the instruction says that he submitted his first application on dated 31/10/2022. Your lordship. The very first page of the instruction, it reflects, your lordship. District level meeting held on 17/12/22 has rejected the proposal of the petitioner by order dated 30/12/22 as per rule number 3 of the government OM dated 1/6/15 and as per point number 4 of the letter received from the Department of School Education, your lordship.
Application, you stand by this, that,
Your lordship,
You-
with regard to the
Just a
submission
minute.
made by the petitioner.
just a minute. So that means, as per your instructions,
Yes, your lordship.
you stand by the date of application as 31/10/2022.
Yes, your lordship.
Not 8/5/2021. I mean, 8/5/2011.
2011.
8/5/2011. And although assuming what the petitioner, though he has not a receipt copy, if his application was submitted in the year 2011, your lordship, he would have to come before this honorable court if there was fairness and immediacy for, and if the benefit in with regard to the scheme was essence for him, your lordship. He slept over his right.
Okay,
Now,
now,
father died 25/3/2011, Lordship. Within a period of 1 year, Lordship, he submitted the application.
Okay.
Lordship.
now in respect of the other cases,
Yes, my lord.
the date is same, date of application.
Date of application is different, Lordship, but speaking order is same, Lordship.
Okay.
Regard to that item 7, your lordship. Item 7. In this case, the petitioners, the date was in the year 2011. Then with regard to item 7, the date occurred in the year 2016, your lordship. So
60.
16, from 17 March, the scheme is stopped. So if this, if the authority has taken for consideration to place some of the matters, if the, since the exams, some process is going on. So if it is to be taken into consideration, so definitely since the scheme stopped from 2017 March, so matters of 16-17, it gains importance. Because after 17 March, consider that after thereafter, compassionate family pension comes.
Before scheme was abolished, Lordship, his father died, Lordship. And before the
Okay.
scheme was abolished, he
But
See,
submitted the application,
we
Lordship.
have your instructions already, isn't it?
Yes, yes.
Let you put that in the form of an affidavit,
Yes, my lord.
that'll be better. We'll
In fact,
issue
Lordship,
notice.
Super,
Yes.
my instruction,
date.
Lordship, they are doing something, Lordship. They are doing something, Lordship. They are.
He's not saying anything also,
Yeah.
to that direction.
He's servicing. Anything, Lordship.
Heard,
whatever, Lordship.
Mr. Your good name?
D.
Bhuya.
my lord.
Heard, Mr. D. Bhuya, learned counsel for the petitioner. Submits that the petitioners agree with the speaking order dated 30/12/2022, by which the date of application for compassionate appointment submitted by the petitioner has been wrongly reflected to be belated. To stop. He submits that, in fact, the application was timely submitted, but not considered by the respondent authority. And later on, through the speaking order, rejected on account of late submission of application. To stop, he therefore submits that the same should be interfered with by this court. Next para, in view of above, if we notice of motion returnable by 4 weeks, Mr. B. Diori, learned government advocate, accepts notice on behalf of
I'm for 1, 2, and 7.
respondent numbers 1, 2, and 7. And
1, 2, and 7.
score is there. Elementary education. Is there score accepts notice on behalf of respondent numbers 3, 4, 5, and 6. Notice is complete. Extra copies to be served to the counsel for the respondents within 2 days. Next para, Mr. B. Diori, learned government advocate, submits that he has received instructions in the matter. Stop such being the position, let the instructions be filed by way of an affidavit on or before the next date. Should we have a date? When can you file?
4 weeks. 4 weeks. 4 weeks, after 4 weeks, any.
Any date? Just again on
Yeah.
10-2. You take back your para-wise comments.
It
Please
is,
file it. Whatever you have, you file it.
yes.
But other matters are same issue. Lordship.
Similar order will be passed in item 7,
In item,
then item number 42, 43, and 44. Okay?
Madam. But can I, date be deferred, Lordship, on 10 February, I have some difficulty, Lordship. After 10 February, any date, Lordship. 20 February after February.
You want a
In the
distant
usual
date?
course, then Lordship, let the matter come then in the usual.
Huh?
Oh.
20.
Also, otherwise, in these matters, the petitioners had approached earlier also before this honorable court.
The issue was different, Lordship. The earlier Lordship petitioner case was not considered, Lordship.
Whatever you have to
Madam.
say,
Yes,
you have said in your writ petition.
my lord.
Whatever reply you want to say, you file in affidavit.
Affidavit.
So if you file your affidavit by the next date,
Yes,
we'll
madam.
take a final call.
Okay,
All right?
I need to say.
He wants a distance date. Give him a date which he wants.
Yes,
Also, in other matters, instructions have not been received.
very good. My lord.
Yes.
That will be fine.
24. Which matters you have no instruction?
Only 6 we have received.
Only
Others-
6,
Yes,
not 7.
not 7.
Okay, that Mr. B. Diori has said instructions, no, that you don't write in other matters. Only in item 6, instructions. Instructions part not required in the other part. But then indicate about the counter affidavit.
Okay.
Yes.
May I please, Your Lordship?
Yes.
Petitioner is retired teacher, my lord. There is a allegation of excess royal, my lord. And thereafter, my lord, by annexure E page 19, there is a proposal from the government, my lord,
Page?
for waive, page 19. Annexure E, under secretary elementary education to the director of English regarding waiving of excess royal amount. because my lord, in view of the Rafik Moses case, my lord, that he being a grade 3 employee and already my lord retired. So my lord, the question of my lord recovery does not arise. And in view of that, my lord, he retired on 16, my lord. That already 9 years has passed, my lord, that pension has not settled. Therefore, the petitioner is before the Honorable Court to expedite the matter, my lord, in the matter of pension, my lord.
What is annexure G?
My lord, G. G is, my lord, that from Director of Elementary Secretary regarding a waiver of excess dwell amount in respect of Simoti Maniman, that from the in the that which happens to, and it is also stated that the said excess dwell is not on account of the para 2, my lord, annexure G page 21. It is also stated that this said excess dwell is not on account of fraud, misrepresentation, collusion, favoritism, negligence, and carelessness, etc. on the part of Srimati Onima Setia, petitioner, retired Hindi teacher. In this regard, a proposal along with the original service book and other relevant paper along with excess dwell statement, waive of excess dwell amount, rupees 1 so only in respect of Srimati Onima Setia, retired teacher, as received from DO Lakhimpur by letter number so submitted herewith for the God
Okay,
for kind information and necessary action.
Okay, you have given a type copy with the wrong date.
My lord,
The date is 2nd January 24th. In your type copy,
22nd January.
no, please listen to me.
Oh, yes, sorry. Date is
The original copy is
2nd
January.
2nd January.
Your type copy says 22nd
wrong,
January, the
Wrong.
wrong date.
Wrong.
But the contents are same. On the last occasion, court has inquired about this. Government was supposed to get instruction. Department, what is the instruction?
Because I have not received instructions. Some time may be done.
Some more time required. Otherwise, you are aware about this.
Well-
You are aware, isn't it? Some trouble was there.
Well-
Government says that, what is this? Director says that this is not a, what do you call, intention or nothing like that, no misrepresentation, no collusion, nothing. And writes back to the secretary. Now, what secretary has done that we don't know. That is what we are supposed to get
Well, I will take it.
information. Please write, peruse the order dated 19. Wherein, learned, number one, who's number one? The counsel for respondent number one was required to obtain instructions with regard to the communication dated 2/1/2024, bracket annexure G. Stop next. Today, Mr. S. Sutia, Learned Standing Counsel, Secondary Elementary Education, submits that she is yet to receive instruction on the matter and prays for further 2 weeks' time. Prayers allowed. List again on.
Please, Lordship. I'm praying for passing over the matter for time being, Lordship. Learned Senior Counsel, Mr. Kane Chaudhary will be appearing. He is on legs, Lordship, in court number 1. Can it be taken up after some time, Lordship?
What is the matter?
This is a suspension from service,
Suspension,
Lordship.
Your Lordship, and DPC has initiated against him. The petitioner under suspension.
It's only simple suspension or prolonged suspension?
Simple.
It is
Or-
suspension. He was suspended on only 13/12/25 lawsuit in December. We have already issued a so-called notice to the petitioner lawsuit. Now the DPA has already been started.
So
let's
suspended
participate
by which date? By order?
on order lawsuit
16?
71. And immediately he moved his honorable court lawsuit on 19th. We have already issued the so-called notice to him, Lordship. And a DP has started. So let him participate in the proceeding, Lordship. Or
Inquiry was conducted by the secretary, so. What is the instruction? Any inquiry report?
yes, regarding whether so-called has been issued or not, whether DP has been started or not, only these things has come. We have to file affidavit, Lordship, in this case.
No. Do you have a preliminary inquiry report? No,
No, Lordship.
because the indication is there in the order last time.
Yes. Before that explanation, an explanation call was given, issued to the Lordship, the principal, Lordship.
What is the interim prayer?
Interim prayer, Lordship?
Suspension orders
The-
to
of
be
the-
stayed.
Yes, Lordship. Already DP has started, Lordship. There's no question of suspending at this stage.
How it started?
We have issued the so-called notice, Lordship.
When?
24/12.
24/12.
Hey, don't did, yeah. By the inspector of school.
Has it been acknowledged? (16/12) suspension, 24/12 show cause.
Yes, Your Honor.
Has he filed any reply?
No, sir. Right, till that, I said that information we don't have. I think he has not filed.
You should write to the undersigned for the same within 7 days. No, you should submit your written statement in defense within 10 days.
Yes.
From the date of receipt of this communication. Then, when did you serve this show cause notice?
That is not there, Lordship. That information I have to take, Lordship. Whether it was someone who is dead, Lordship, that instruction is not here.
So 10 days will count from that date only.
Or
From
from
the
the
date of receipt.
Date of receipt.
Get the instruction
Yes, yes.
After some time, maybe.
after some time.
Yes. Level.
May I please? My Lord, the order passed by this honorable court, Lordship will find at page 19.
Yes.
Yes. Then, my Lord, page 20 is the, my Lord, date of order. 14/8/2025. Then Lordship kindly see page 49, the operative part of the order. Page 49, para 26. Page 49, para 26. Yes, it says, my Lord, upon such circumstances, this court is of the view that the impugned order dated so and so fails to withstand with the legal scrutiny. The same was passed in contravention of the principle of national justice without affording any opportunity of being heard to him, and accordingly the same stand set aside and quashed. Now, my Lord, last portion, Lordship will find page 50, para 28.
Any time frame?
My Lord,
Any time frame given?
not exactly not time frame is there. But still, my Lord, he is, my Lord, since, my Lord, 20 years, more than 20 years, he has been working with minimum, my Lord, pay scale. So by this order, my Lord, the respondent was directed to pay the, my lord, minimum pay scale.
When issue notice,
Mal.
who are the respondents?
It's only, my lord, Commission Secretary and, my lord, Director, higher education.
Part Mr. M.U. Mondal, learned counsel for the petitioner, who submits that despite copy of the judgment and order dated 14/8/2025, passed in WPC number 7163 of 2023, having been served to the respondents, they have failed to comply with the said direction given in the said judgment. Next para, issue notice returnable by 4 weeks. Steps within 3 days by speed post.
Deep loads.
My lord, basically, my lord, petitioner before your lordship approached my lord against the page 40 communication, my lord. But subsequently, as per information, my lord, government, my lord, themselves, my lord, did not acted upon this communication, my lord. Page 40, my lord. It will come from.
What is this page?
My lord, as per my lord, this communication, my lord, they have fixed 2 dates, my lord, 10th and 11th December, to consider, my lord, compassionate appointment of, my lord, few departments, my lord. This petitioner before your lordship belongs to, my lord, education department, but here education department is not missing, my lord. Is missing, my lord, therefore he approached, my lord. But subsequently, as per information, my lord, this letter is not acted upon. Now they are going to reschedule the date of consideration by the DLC, SLC, etc.
কি কৈছে বুজা নাই
Here all, my lord, 16 departments, 8 departments for, my lord, 10th December and another 8 departments, my lord. So, my lord, it is in fact plus one.
What is your case?
My case is that, my lord, they ought to have, my lord, as per, my lord, judgment, they quoted, my lord, Abdul Kadir Bakshi, my lord, my department should have been, my lord, considered, but it was not listed. But nevertheless, my lord, this communication is not acted upon.
Upon perusal of page 40, your lordship, it is the prerogative will be on the hand of the government, your lordship, to place phase wise. It seems so. They have taken selected certain departments, 10 or 12 or whatever. So the cases of those departments, the government has decided to carry out the process. Your
Page
lordship.
manner.
So the petitioner's apprehension is that this particular department also needs to be. So that I don't think will be in the hand of the petitioner to suggest that or claim that. Because otherwise that Department of Higher Education is there in the right side column, your lordship, 7 number.
Here I am, my lord, elementary, my lord.
So
And, my lord,
it is
this judgment, my lord, they are quoted.
prerogative of the department that in what manner or in what place they carries out. Yes.
Nevertheless, my lord, they have not acted upon, my lord, and now they are rescheduling the, my lord, dates, my lord.
Again, I'm asking you, what is your case?
My lord, this is the case, my lord.
This is not the case. Tell me.
My
what
lord,
is the
my
case?
case is that, my lord, as per my lord,
Just a minute. Showing me one annexure, order dated so and so. They're not doing this. What is this?
yes, my lord.
At least tell me the background.
Yes, my lord. My case is that, my lord, page 28, my lord. This honorable court passed the, my lord, judgment, my lord, in favor of this present petitioner, my lord, to consider her case also, my lord, for compassionate appointment, my lord.
Mother of the petitioner.
No, my lord, petitioner, my lord. Petitioner applied for compassionate appointment, my lord, and this honorable court, my lord, by page 28, annexure 4, directed, my lord, to consider her case for compassionate appointment, my lord.
Page 28.
28, my lord. And the relevant portion, my lord, page my lord, 38, my lord, direction was given accordingly, my lord.
Then
Then, my lord, they issued, my lord, this, my lord, notice, my lord, selectively, my lord.
where?
My lord, it was issued, my lord, on 16 November 2025, my lord. Page 40, my lord. And my lord, they quoted that judgment, my lord.
Read the notice.
Notice to Poho.
Huh?
Notice to Poho.
Page 40, my lord.
Please read it.
Yes, my lord. Enclosed herewith, please find a copy of communication number so-and-so, dated so-and-so received from the personnel department, highlighting the urgent need for compliance with the Honorable High Court's order dated 3/4/2000 in WPC number so-and-so, along with other connected cases pertaining to appointment on compassionate ground.
Just stop there.
Yeah.
Your case number is not 342.
No, my lord, but my lord, with reference of this judgment, my lord, my case was also disposed of. my lord. And this part of this judgment is also quoted in my judgment, my lord. You kindly will look page, my lord, 30, my lord. Paragraph 4, my lord.
Come back to 40.
14, my lord.
40.
Yes, my lord. Same judgment, my lord.
Now, column 2 portion.
No, no, first.
In this, all departments are requested.
Yes.
Yeah, yes.
So what is wrong in page 40?
Page 40 is not, my lord, as per the judgment, my lord, because judgment says, my lord, all should be considered, but they also, my lord, only without mentioning that subsequently they will consider other department or me, my lord, only, my lord, they kept on the board, my lord, only 16 department, my lord. On 10 December, 8 departments, on 11 December, 8 departments, my lord.
You are under which department?
My lord, I am elementary education department, my lord.
Elementary. Elementary.
Elementary. But my lord, there is a development, my lord. Subsequently, my lord, they have not acted upon this communication, my lord.
Then?
And therefore, my lord, I am saying.
Then your case is premature.
No, my lord, not my infructuous.
Or infructuous. We'll dismiss it as infructuous then.
Close, my lord, kindly, my lord. The communication against which, my lord, case was filed, my lord, it was not acted upon, my lord, as per instruction, my lord, and accordingly matter is not infructuous.
Or you want to withdraw it?
Can you, this observation kindly may be given?
What observation?
This communication against which the petition was filed, this is not acted upon, my lord.
None. That is your.
No, the meeting was not held, my lord, on
How
that
can that
2 days,
be
my lord.
based upon your submission?
You withdraw it, that's all. Or you're not pressing it, that's all. Beyond that, we're not saying anything.
Then, my lord, matter may come up. I am, as per my instruction, my lord, meeting was not held. My learned friend is not sure. Meeting was held or not.
No.
Whether meeting was held on that.
I don't know. Lordship,
You are controverting yourself. Sometimes
No, my
you're
lord,
saying not.
subsequently, my lord, this case was.
Sometimes you're saying like that.
My lord, this case was filed earlier, my lord. And I am now, my lord, the latest instruction is that, my lord, meeting was not held on that 2 dates, my lord.
So you withdraw it. What is there to examine in this case?
Infructuous, my lord, as per my instruction, my lord, meeting was not held.
Okay, Mr. A.H. Borbuya, learned counsel for the writ petitioner, submits that the writ petition is become infructuous even before moving of the same. In view of above, the writ petition stands disposed of infructuous.
My lord.
Mr. B. Dury, learned counsel, appears for the learned government advocate, appears for the official response.
Yes. Deep level.
May I please, your lordship? Lordship, this case is that, my lord, here, my lord, the petitioner's area salary is pending, my lord, that has not been paid. My lord, lordship directly come to the page 22, my lord. The petitioner was working as a part-time lecturer in the Polytechnic, Karimganj Polytechnic, my lord. He has been released from service, and during his service period, my lord, kindly turn to page 22, my lord. This is the forwarding letter issued by the principal. My lord, I am reading this. With reference to the subject stated above, I would like to forward herewith a non-royal certificate duly signed by the undersigned and countersigned by the Treasury Officer, Sri Bhumi, to provide area budget of rupees so and so for disbursement of salary of 4 hours of part-time lecturer for the month of January 2024 and February 2024, which was not drawn in the year of previous to year 2023-24. In this regard, my lord, non-royal certificate has been issued. Here, my lord, my name at serial number 4, my lord, at page 23. For the month of January, 72,000. For month of February, 72,000. This is the amount, my lord. And next page is the statement, my lord. Next 2 pages are the statement. This is the admitted, my lord. In this regard, my lord, earlier occasion, my lord, another 2 persons approach your lordships. In this regard, lordship has issued a notice. And that case, my lord.
What is page 24, 25?
25 is the statement, my lord. That is the statement for the month of February, and 24 is the statement for the month of January. Another 2 persons, my lord, Shyamol Krishna Roy and Kohinoor Borbar, also approach your lordship, and lordship has issued a notice. That is the order, first order. Lordship's order, and this is the last order. By this order, my lord, this case has been fixed on 22nd of this month for disposal, man.
So why are you giving me all these orders? Is it necessary?
My lord, they on a notice may be issued and fix
That's
together.
not what is there? If it's for disposal, common order, then different thing, but
Yes, lord.
only for issuing notice, you don't have to show me all these things.
Yeah, notice may be issued and fix it togetherly on 22nd, my lord.
Heard, Mr.
D. Borua.
D. Barua, learned counsel for the petitioner. Submits that by filing this writ petition, the petitioner seeks for a direction to the respondent authorities concerned to release the area salary for the month of January and February 2024, amounting to rupees
70.
total how much?
144,000
1,44,000,
together.
which is the monthly salary and not paid to the petitioner while working as part-time lecturer of Karimganj Polytechnic. Stop. Learned counsel submits that the principal of the Polytechnic has also certified that the petitioner has not drawn the salary for the said 2 months. In view of above, issue notice motion turnable by 22nd of January.
Yes. Matter may be taken up togetherly, my lord.
It's P.K. Bora. Accepts notice on behalf of respondent numbers.
1 to 4. I'm S. Bhuya.
I'm sorry, S. Bhuya. S. Bhuya accepts notice on behalf of respondent numbers. 1,
1 to 4.
Fin-
1, 2, sorry,
finance
1,
also?
3 and 4. Sorry.
I was wanted to.
1, 3, and 4. Well, Ms. Anand Barua, SC Finance accepts notice on behalf of respondents 2 and 5. Notice is complete. List again on 22/1/2026 along with WPC number 6090 of 2025.
Oblige, your lordship.
There was 12.
Lordship, this writ petition is being filed pursuant to a liberty granted by the Honorable Supreme Court. Would Lordship kindly come to the order passed by the Supreme Court at page 282? Annexure 15, page 282. May I just place it, Lordships? After hearing so and so, we are of the opinion that the petitioner is entitled to challenge the order dated 25/4/2024 passed by the Department of School Education, Government of Assam by filing a writ petition before the High Court. If such a writ petition is filed, it shall be taken up and disposed of on its own merits without being influenced by the observations in the order impugned before us. And this is precisely the order that is impugned before Lordships. I'll just tell briefly, Lordship, what is the background. Why did this case first reach the Supreme Court and now the Supreme Court has said, you go back?
No, you had gone to Supreme Court.
Yes.
Against what?
Against contempt order, which order is at Lordships. It starts at 272. We went against the order dated. That is what, if I briefly tell Lordship, then I chronologically, then why we reached here. If Lordship may so permit.
No, you just come straight to the point, page 280.
280, Lordship.
Is this what you went to the Supreme Court with?
No. We went against the order at page 272.
272.
Yes. 272 followed by the order at 280.
272 was a compliance order.
Yes.
No,
Thereafter, we filed a contempt.
no, just a minute. 272, what is 272?
272 is a order passed in our initial writ petition when our cases were not being considered.
Writ petition.
Yes. Then the learned judge thereafter said, you please pass a speaking order in respect of them. The speaking order was never being passed, so we filed a contempt. Now, in that contempt, this order came to be passed, 5/9/2005, which is at page 280. We went against this order because I will not blame the court, because then what happened? Without any instructions, our petitioner came to say that a speaking order has complied with the initial directions. And that is what my lordships have, the court has also recorded. So therefore, we went against this order, where unfortunately, our lawyer then told the court that the speaking order is sufficient compliance. Since it was not sufficient compliance, we went to the Supreme Court and explained this. And that is when the Supreme Court said, very well, we give you the liberty to challenge the speaking order itself.
That liberty was required to be taken from Supreme Court. You could have come here straight away.
No, we could not. Once they have said that the speaking order is compliant.
No.
Please see the next statement. Mrs.
No.
M. Sharma. Mrs. M. Sharma, learned counsel appearing on behalf of RC Saikia, learned counsel for the petitioner, agrees with the submission. And what was the submission? Mr. So-and-so, learned counsel for a response number 1 to 4, submits that the order of this court has been complied with. In support of his submission, the learned counsel has produced a copy of the order dated so-and-so, passed by the Secretary of the Government of Assam, Department of School Education.
Where is the order?
That is the speaking order, which now is a matter of challenge.
Where is that page?
That is page 273. Essentially, the case is this, lordships. If I may just put it.
No, just a minute. After careful consideration above mentioned, the petitioners are not eligible for provincialization
Yes.
of so and so. So it is,
Under the 2017 Act.
so this disposed of.
Yes.
So basically the order was that
To consider a case under the 11 Act.
to examine the claim of the petition in the light of the decision rendered above. And if found the petitioner similar situated, similar relief will be granted with effect from so and
Yes.
so.
So,
Which exercise shall be undertaken within 3 months.
correct, Lordships.
So they say that you're not entitled to.
No, we are not entitled under the 18 Act, 17 Act, but our consideration should have been under the 13 Act. Our case was under 13. Our case, if Lordship will kindly have a look at the documents.
No, that argument will go on in the writ petition.
Yes.
No problem.
Hmm.
What I want to say is that, you see, court directed that examine and dispose of, and if they found to be in line with that, give them the relief. Rightly or wrongly or whatever, they have disposed of in one manner that it's rejected.
Lordship.
In the meantime, the contempt was there, so person says that, okay, they have disposed of your representation or they have considered it by a speaking order. So it's like a compliance of the court's direction. Court did not say that by any means give them this relief. By any means give them this relief. That was not the thing. Court said examine, yes, found, give them. They found that not entitled to. So there was always a liberty on the part of the petitioner to challenge it again in a writ petition.
No,
Why did you have to go there and say
Yeah,
that?
because I'll tell you, Lordship. Let me
It has been,
explain.
door has been closed for us because that observation was there, that somebody has mentioned that court's orders complied with.
So, because if in the earlier round, we agree that the compliance has been sufficient, how could it be? Because if Lordship will see the last line, the order, we have been found ineligible under the 2018 Act, 17 Act. Our consideration should have been under the 2013 Act. That is why we said that once the learned counsel appearing for us says that this is sufficient compliance, our hands gets tied. That is precisely why we had to go to the Supreme Court.
Okay, on that note, we'll issue notice. Heart, Mr.
Yes.
M. Goswami, learned senior counsel, assisted by Mr. R. Singh for the petitioners who submits that the petitioner is aggrieved with the order dated where's the date?
That is the 25/4/2024.
25/4/2024, bracket annexure 14. Passed by the Secretary to the Government of Assam, Department of School Education, rejecting the claim of the petitioner with a finding that they are not eligible for provincialization of their services as per the Provincialization Act of 2017 as amended in 2018.
We are agreed because our cases needed to be considered under the previous Act, 2013 Act.
Learned senior counsel submits that the consideration of the petitioner should have been under the, what is the full form of that act?
This is Lordship, Assam Education Provincialization of Services of Teachers and Reorganization of Educational Institutions Act 2017.
17 or 13?
Say Lordship required a 2013 Act.
You say that it should have been considered under 2013 Act.
Yes.
Give that full form.
Yes.
You write that.
2013 Act is Assam Venture Educational Institutions Provincialization of Services Act 2011, which got effect. The provincialization started from 2013, but the act is of 2011.
11.
Yes.
That is already struck.
That is struck down.
Struck
That is
down.
another aspect of the matter.
Struck
Despite
down.
that struck down.
Now re-amended, your lordship.
Assam Venture Educational Institutions Provincialization of Services Act 2011. Our consideration should have been under that.
Under that.
Under that.
You want consideration under the the Struck Down Act.
Yeah, because now there's a division bench order judgment
Ah.
of this court,
Ah.
which says if your recommendations were already done before the act was struck off, then your vested rights gets crystallized.
Okay, what is that order? Division
Yeah.
bench?
Division bench order is this one, worships. Mohor Ali Sheikh versus State of Assam. GL 2024
Okay,
5
okay.
GLT.
I got it. The learned senior counsel submits that this is because the same is the same has been, the same is permissible in view of the bench judgment rendered in Mohar Ali Sheikh and others versus State of Assam and another.
144.
Reported in 2024, 5 GLT 689,
6
paragraph
144.
Paragraph
Where
one.
it, where it interprets section 24.
within bracket paragraph 144.
Para 144 and
Stop, next para. Be it stated herein that the petitioners initially approached this court by filing WPC number 937 of 2019, which came to be disposed of by order dated 4/9/2019, by directing the respondent authorities concerned to examine the claim of the petitioner in the light of the decision rendered in WPC number 6804 of 2017, and to take a decision within a time frame. Stop. Since such decision was not forthcoming, the petitioners were compelled to file contempt petition. That is contempt case C number 451 of 2020. Stop. During the pendency of the contempt petition, the impugn order dated 25/4/2024 came to be passed, and accordingly, the contempt petition was closed. Stop. It was also observed that the petitioners, the counsel for the petitioners was agreeable that the court order has been complied with. Stop. However, the petitioners, in view of such an observation, apprehending that they would be precluded to challenge the impugn order dated 25/4/2024, approached the apex court by filing SLP C number 30867 of 2025. Stop. The SLP came to be disposed of by order dated 4/11/2025, with an observation that the petitioners will be entitled to challenge the order dated 25/4/2024. Without, and the same should be considered and disposed of on merit without being influenced by any observation made in the order dated 5/9/2025, by which the contempt petition was closed. Stop. Next para. Accordingly, the petitioners are now before this court through this instant writ petition. Next para, in view of above, issue notice of motion returnable by 4 weeks.
Your Worship, I'm just seeking a interim stay. Because the posts may not be filled up. We have,
No, your lordship.
if
And
they
this is
fill up the
this way,
post,
Your lordship.
if they fill up the posts, then what are we litigating for?
It's a 2024 impugn order lawsuit. Now they want the post to be kept vacant lawsuit.
How can it
Yes,
is,
your lordship.
no, Lordship will kindly see, we have already prepared a chart, if Lordship will see a para 3. Para 3 of our writ petition, Lordships. We have clearly demarcated, these are people were recommended, they themselves accept that they were recommended in that speaking order. But because of their fault,
Miss P. Das, Learned Standing Counsel, accept notice on behalf of
Respondent 1 to 3.
order number 1, 2, and 3.
Yes, Your Lordship.
Anybody else? Huh? Ms. R. M. Barua, SC Finance, accepts notice on behalf of respondent number 4. Notice is therefore complete. Extra copies to the learned counsels for the respondents within 2 days. We'll have a short date. You get instructions on the interim.
Yes, yes.
I'll not make any.
But ultimately, this is the order is of 2025, the 5/9/2025 order. They are saying that the speaking order today they are projecting is of 2024, but the speaking order not served on us on 5/9/2025. So it is not that we are very late.
All right, we'll, like
So
I
at
said,
least
we'll-
as an interim arrangement, Lordship, there should be some protection.
no, we'll consider the interim thing on the next date. Let them also arrange their instructions.
So let it be at least subject to. Let it be subject to.
Issue notice on the interim prayer as well. Returnable by, when do we have it?
Whenever it's convenient for them, Lordships, but at least let it be subject to the.
February law. February, first week of February.
Can we have it before that? 29th,
Yes.
Yes, Your Lordship.
returnable by 29th. Learned counsels for the respondents to obtain the instructions on or before that date.
29th.
And the interim prayer will be considered on that date.
29th to 30th, Lordships. Is 30th convenient? 30th January? Subject to Lordship's convenience?
It's convenient, with the parties, no problem. So 30. 30. In the beginning part also, notice of motion, na, I say, returnable by 30. Interim also 30. Get your instructions.
Yes, Your Lordship.
We'll see.
They should not fill up in the meantime, Lordship, because it should not be a case of fait accompli. My Lordship will kindly appreciate, because this is a case which is we had to go all the up. They have been recommended not once, twice, but despite their mistake, we are still litigating. So to that extent, if Lordship can have a view, sympathetic view.
Your Lordship, in
42,000 people have been provincialized. The 16 people have been left out, and they themselves accept that we recommended them.
It's a short date, I don't
short
think.
date,
so.
very
So
short.
let it be
date, Your Lordship.
subject to this writ petition, Lordship, at least till the next day they should.
No, Your Lordship.
At least let them make a statement. If Lordship, let them be fair. Let them be fair and make
No.
a statement.
At
That
least
is all
they
I'm
cannot make
insisting.
any statement, Lordship. Let it come on returnable there on that day, Lordship will consider whatever action Lordship will pass, Lordship.
We'll see on that. Yes.
Very good. Very grateful, Lordships, grateful.
May I please, Lordship? Lordship, petitioners are STNDs are Arabic in different ME Madrasa, than ME Madrasa now upper primary school, Lordship. They were excluded under the Act of 2017. Subsequently, they challenged the validity of Section 3111. This honorable division bench of this honorable court declined to interpret Section 3111, Lordship. Now, they are before your Lordship for passing a similar order, page 61, Lordship. Yeah, for primary.
Yes, please carry on. Please
Lord-
carry on.
I am praying for similar order, Lordship, page 61. Your Lordship may kindly
Page 61.
Yes, Lordship.
Yes, what do you say?
Well, like some time, maybe along, at least 1 week, we have to verify. And
Verify what?
similar order may not pass. Because his prayer for appointment of provincialization of Arabic teacher. So some language. Next week,
Next week, you want to come? No BU for you.
well,
No BU holidays for you. You want to come next week?
well, we have to verify whether it is similar or not. Well,
You said next week. Next week is a BU holiday. Do you want to come on BU holiday to court?
after being, well,
Then why you said next week?
why, whether it is similar or not, well, we have to verify. Well. We have to go through the order by the color case, Chandra Roy.
Page 57 is the linkage, Lord.
Yes, well,
Page
case Chandra Roy, we have to verify.
All that they're saying that is that they are also covered by this order.
Yes.
So they are required to file the respective individual representation. And you can do all the verification required. If they are found to be covered, you give them the
Yes.
benefit. If not covered, you don't give. That's all. What verification requirement now? Are you saying that you'll verify now first, and if you find that they are covered, then you'll give them the benefit without order of this court also? If you say that, we'll give you time.
Okay, man.
If not, what is there? They are supposed to file a representation
Well,
and say that we are covered. Please consider our thing. Heard Mr. S.H. Raman, learned counsel for the petitioners who submits that the petitioners are working as
Assistant teacher, Arabic.
assistant teacher teaching Arabic language
Arabic language
in upper primary schools.
in upper primaries.
And it is their case that they are eligible to be considered for provincialization of their services in terms of section 3(1) bracket small Roman 11 of the Assam Education open bracket provincialization of services of teachers and reorganization of educational institutions close bracket Act 2017. Gustav, the learned counsel at the outset submits that a similar matter was taken up by this court. The similar matters were taken up by this court. And they were all disposed of by a common order dated 22/10/2025. With the lead case being, what is the lead case?
WBC number 1068/2022.
This is link case, not the lead case. With the lead case, you cancel that.
Could mean case or order. Confusion of annex logo in it. They have not annexed the first page of the order. ma'am.
That is what I wanted to know the number.
I am providing, Your Honor, after some time.
Okay, with the lead case being WPC number dash. Give it to her, okay? Give it to her, the case number, lead case.
Lordship.
Bracket annexure 9. Top Delaware Council therefore submits that the instant writ petition can also be disposed of. May be disposed of in similar lines. Ms. N. Foucault, Learned Standing Council, Elementary Education, submits that in view of the direction passed in the earlier writ petitions, court may consider and pass appropriate orders as deemed fit and proper. Next para, in view of above, the writ petition is disposed of by directing the writ petitioners to file their respective individual representation before the Director of Elementary Education, Government of Assam, within a period of 15 days from today. And the said authority, upon receipt of the representation, shall consider the same by taking into account the provisions of section 3(1) small Roman 11 of the Act of 2017. In the beginning part, you write that, okay? Act of 2017. Act of 2017, and dispose of the representation within a period of 4 months from the date of receipt of the same. By way of a speaking order. With the above direction, observation and direction, the writ petition stands disposed of. The petitioners, how many petitioners are there?
17. Lordship.
The petitioner number 1 shall file a copy of this writ petition before the Director of Elementary Education, along with a certified copy of this order, and also along with his representation, which shall be considered which shall become not required, along with the copy of the representation. Full stop. The remaining petitioners are not required to file a copy of the writ petition along with the representation.
Leading case number is 5072/2021.
5072 of
2021.
2021. Okay,
Obliged.
in the file. Wait, please, Lordship, I beg your indulgence, your Lordship. As for intervention, item number 20 to Lordship, so I am not feeling well, your Lordship. And also, your Lordship, the other side, item number 28.
They
20. They have also missed out.
submitted, your lordship.
Which item? Item 28, your Lordship. 28. 28. You want adjournment? Yes, your Lordship, because they have also,
Your lordship, instruction is awaited, your lordship. So kindly grant us 2 weeks' time, your lordship, to obtain the instruction.
yes, paid for by the parties list again after 2 weeks. At one date. On so and so.
Deeply obliged.
Don't say 2 weeks, you straight away say it as paid for by the parties list again on 4/2.
Deeply. Item number four.
May I please, Your Lordship?
Excellent.
Yes.
Yes, Lordship, the impugned OM is page number 47. This OM has already been under silence before this honorable court in another batch of writ petition, my lord. Lordship, maybe issue notice and take with the other similar matters. 47 is the impugned OM.
What is the other case?
4125, no?
4001.
Other case,
4001 of 2025.
4001.
1 of 2025 and
Primarily-
6796 of 2025. Eta amar.
2 cases.
Yes,
Heard Miss
P. Bora.
C. Bora, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the office memorandum public executive order dated 22/5/2025,
Lordship.
bracket annexure H. By which the PhD degree awarded from the which university?
Petitioner is from OPGS University and 4 universities degrees are restricted. I am for a OPGS University.
What did I say last time? By which? By OPJS University, Churu, Rajasthan. Apart from 2 other universities have not been accepted. Or not following the UGC regulations concerned. Ustav, the learned counsel submits that, in fact, two other similar writ petitions have been filed challenging the impugned office memorandum of the executive order, namely WPC number 4001 of 2025 and WPC number 6796 of 2025. Stop. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. S. Bhuya. Learned Standing Council, Higher Education, except notice on behalf of respondent numbers 1, 2, and 3. Petitioner to UGC, anybody? Standing Council?
Yes.
Who?
Someone.
Petitioner to serve notice to respondent number 4. Through Mr. A. Chamua. SC UGC. Stop the acknowledgement received from the Learned Standing Council UGC shall be submitted before the registry as proof of service. Extra copies be served to the Learned to Mr. S. Bhuya within 2 days. This is the matter again after 4 weeks, along with WPC number 4001 of 2025 and 6796 of 2025.
Lordship, item 34 that was mentioned in the morning, Lordship. So I have no objection to that, only that if date may be fixed on. Lordship. It was on 2 week, they have it adjourned for 2 weeks, Lordship, and date may can be fixed. They have informed me, they took my consent that they will adjourn the case, but on the date may can be fixed.
34. Some date may be given.
28, not 28 January. We have already complied, we have filed the affidavit, Lordship. I'm going to say the case is lingering, Lordship. Yes, okay.
Okay.
Sure.
Yes.
The matter pertains to a compulsory appointment, my lord. Here, my name was recommended for grade 4 post by the SLC.
Date?
That is, my lord. Now, I'll just take you to the order, my lord. At page 50, my lord. 51 is the effective part. Due to lack of vacancy, my case was rejected by the SLC. Against that, my lord, I approached this honorable court by filing 3370 of 2024. Your lordship will find the order at page 51.
Then
My lord, thereafter, my lord, the notification was issued, my lord. I'll take you to the operative part, my lord, at page 52, paragraph 5. When there was a clear vacancy for the year 2006-2007 for appointment on compensation ground under 5% reservation, this court is of the considered opinion that the state level committee has erred in its decision while rejecting the case of the petitioner on the ground of lack of vacancy. Accordingly, the minutes of the state level committee is so-and-so is set aside, and quasi insofar as the petition is concerned, the matter is remanded back to the state level committee to reconsider the case of the petitioner in terms of the recommendation made by the DLC in its meeting held on so-and-so. In the event of, if the SLC comes to the finding there is no vacancy for accommodating the petitioner for the year 2006-2007, the SLC shall invoke clause 15 of the OM and thereafter pass appropriate orders. Let such exercise be taken and completed in the next immediate sitting of the SLC. Well, today, till date, my lord, my case has not been considered, my lord. But prior to passing of the order, if your lordship kindly comes to page 48, Annexure 6. This person office manager, my lord, where, my lord, the time frame was fixed, my lord. 31 prior, all applications prior to 31/3/2017 would be considered, but thereafter, my lord, no fresh consideration. Now, pursuant to that, my lord, this notification was under challenge in a writ petition, my lord. And in particular, the writ petition, my lord, said that you consider all the applications. Pursuant to which, my lord, at page 53, Annexure 8, applications were called for from the, my lord, eligible candidates. And in fact, my lord, in terms of this notice, my lord, we
OM does not bar you, isn't it?
Yes, my lord, exactly.
It does not bar you.
The only thing, my
Who
lord,
died on or before 31/3/2017.
no, my lord, here the only problem is, my lord, my case has not been considered as yet, my lord. But the fact remains,
No,
when I
that's
approach
another-
the authorities, my lord.
That's another thing. What I was indicating is that you have shown me that OM.
Yes, my lord.
OM says that who died before 31/3/2017 will be considered by the scheme.
True.
Not after that.
True, my lord.
And here, who died? Your father.
My father, my lord.
died on 27/3/2012,
12.
much
Yes.
before that.
Yes, yes, my lord. In fact,
So OM does not come in the way,
exactly, my lord. Now,
Then?
the problem is, my lord, this OM was challenged in a batch of writ petitions, my lord.
right?
Now, the authorities are of the view, my lord, that since I have not challenged that particular OM,
Hmm.
it will come into the way. That is the limited prayer, my lord. So, in fact, there are a number of writ petitions which have been filed pursuant to that, my lord. If your lordship finds that the one at page 66. Only thing, my lord, that OM will not come into the way with that observation if your lordship disposes of, my lord, in the same lines, my lord, my regards to the matter.
Lordship, my view, on perusal of that page number 52, your lordship. Page number 52, your lordship.
Yes.
That when there was a clear vacancy for the year 6/7 for appointment on corporation under 5% reservation, this court is of the considered opinion that the SLC has erred in its decision while rejecting the case on the ground of lack of avail. According to the minutes of SLC committee dated 16/6/16 is set aside and quashed insofar as the petitioner is concerned. The matter is remanded back to the SLC to reconsider the case of the petitioner in terms of the recommendation made by the DLC in its meeting held on 11/9/13. In the event if the SLC comes to the finding that there is no vacancy for accommodating the petitioner for 6/7, the SLC shall invoke clause 50 of OM dated 1/6 and thereafter pass appropriate. Let us such exercise be taken and completed in the next immediate sitting of the SLC, your lordship. That particular order was passed in the year on dated 26/5/2025. So the order is of its own, your lordship. It stands, your lordship. So in case, because I understand the effectiveness of the order even to your lordship. So my view is that your lordship, if the same is not complied, your lordship, the petitioner can come through contempt, your lordship, because it stands. Because another further order will just dilute the matter of the petition. It stands, indicating the clear vacancy. After that also, if he wants to opt for, that is up to the petitioner.
It will dilute or reinforce. It will dilute.
Yes, it will be similar to other cases, because here it has, the order has specific effectiveness, your lordship. So I think he should go for, if in case if it is not placed, he should go for contempt. Then
Contempt will, my lord, ultimately it is not only thing, my lord. If your
and
lordship, that is my
after
prayer.
that also, if he insists, then your lordship may.
My lord, only thing, the order, the OM was passed on 18 September 2024, my lord. The order passed in my case was of, my lord, 26/5/2025, my lord, pursuant to the OM, my lord. My prayer in the writ petition, if your lordships can come to page 19. Well, very limited prayer, my lord. It's not that, my lord, the SLC has not set in the meantime, but contempt, my lord. Now here, the second prayer, my lord, a writ in the nature of mandamus should not be issued directing the respondent not to give effect to the OM dated so and so. Let them reconsider, my lord. In fact, there are number of petitions in that line.
That's what I was telling you in the beginning.
Yes, my lord.
OM
Lordship
does not
was
bar
absolutely
your
correct.
case.
Yes, yes.
Does not
Lordship
bar
was
your
absolutely correct.
case.
That is true, my lord.
It
It is
came
not being
only-
considered, my lord, only
You know,
because.
it's only for the who expired after 2017.
Yes, yes, yes.
So, Mr. Dev is also right. There's already an order passed by this court
True,
directing
true,
that
true.
you.
So lordship will dispose upon that in lines, my lord. That at least, my lord, the OM will do not affect me, my lord. In my paragraph 19, I have stated, my lord, of the writ petition, my lord, page 16.
Heard Mr. R. Day, learned counsel for the petitioner, and Mr. B. Diori, learned government advocate for the state respondents, and Ms. S. Kuat, learned standing counsel. Who was that? In for?
I'm for 1, 2, and 5, your lordship. And my colleague for 3 and 4.
Full education department, bracket elementary. Stop having regard to the nature of the case projected by the petitioner. The writ petition is taken up for disposal at this stage itself. Next paragraph. The petitioner earlier approached this court by filing WPC number 3370 of 2024. And the same was disposed of by order dated 26/5/2025. By setting aside the state level committee meeting minutes dated 16/6/2016, insofar as the writ petitioner was concerned. And the matter was remanded back to the SLC for reconsideration of the case of, for reconsidering the case of the petitioner in terms of the recommendation made by the district level committee in its meeting held on 11/9/2013. Stop such direction was made after coming to a finding that there was clear vacancy for the year 2006-2007 for appointment on compassionate grounds under the 5% reservation quota. Stop. Despite the direction, since the case of the petitioner has not been considered, and the petitioner apprehending that his case will not be considered in view of the office memorandum dated 18/9/2024, bracket Annexus 6, issued by the government of Assam in the Personal B Department, has approached this court once again. Stop. Next para. It is seen that there are no materials to indicate that the order dated 26/5/2025 passed in WPC number 3370 of 2024 has been challenged before the appellate forum. And further, the OM dated 18/9/2024 provides for a bar to only those persons whose parents have expired on or before 31/3/2017. Whereas, the father of the petitioner admittedly expired, died in harness on 27/3/2012. Stop. Therefore, the office memorandum cannot be a bar for considering the case of the petitioner. Stop. The state government in the personal department have also issued notice on 30/8/2025. And also an executive order dated 30/8/2025. But having regard to the specific direction given by this court on 26/5/2025 in WPC number 3370 of 2024. The same cannot be a bar for considering the case of the petitioner in terms of the state direction. Next para, in view of above, the writ petition is disposed of in terms of the order dated 26/5/2025, and the respondent authorities will be required to comply with the same. As was directed. Writ petition stands disposed of.
Timing 9.
May it please your lordship.
Yes.
My lord, the petitioner is working as a LDC in a particular higher secondary school in Borpeta district. My lord, he is agreed by an order of suspension which was issued by the authority, my lord, which
16,
your
12,
lordships will get at page number 69.
16, 12,
69, sir.
16, 12, 2025.
Yes. In pursuance to letter dated received from the Office of the Director Secondary Education, Mohammad Ilyas Ali, LDA of Senga Higher Secondary School, Borpeta, is hereby placed under suspension under Rule 6(1) of the Assam Services Discipline Appeal Rule, pending trial of a departmental proceeding. Now, my lord, it so happened, my lord, in the meantime, after filing this writ petition, a show cause notice also has been issued to the petitioner. Now, my lord, on the last occasion, Lord, an instruction was placed before this honorable court, my lord, where, my lord, an instruction was given to the Learned Standing Council, my lord, who placed it before the honorable court. My lord, we could lay our hands to that instruction, my lord. In that instruction also, my lord, there is no allegation against the petitioner. Now, my lord, I'll give a brief background of this case, my lord. What had happened? The petitioner is working as an clerk in this, my lord, particular Senga Higher Secondary School. Now, my lord, that particular school where about 8 feeder schools, students of 8 feeder schools appear in HSLC and HSLC examination under Senga Higher Secondary School. Now, my lord, it so happened there is another school amongst that 8, that is Senga Girls High School. Now, that school does not have much of the enrollment, my lord. The principal of that school and principal of another, my lord, private school, they have done some mischief. What they do, my lord, at the time of registration, when the students are in class 9, they take registration in fake names. When, my lord, in the next year, when the students are supposed to appear for matriculation examination, what the modus operandi that is being adopted in this case is, my lord, those names are changed in collusion with the secondary board officials. That is how, my lords, 9 students were identified. Now, I am a clerk. What is my capacity to do any mischief in this scenario, my lord? I've got no role in registration of the students. As a clerk of this school, I do my duties as whatever is assigned to me. Now, my lord, I have been placed, my lord, suspension is not a punishment. But then, my lord, to place a person under suspension, there must be some substantial materials. What are those? Now, the principal, he has not been suspended. The principal of headmaster of the Senga Higher Secondary School has not been, suspended. No any disciplinary proceeding has been taken. And there is another clerk by the name of one Mr. Bharali, who looks after the registration work. He has also not been placed under suspension, nor any action has been taken. But I have been picked up just for nothing. So my humble submission is, my lord, this is an abuse of the process of law. There must be some material. Well, I as a clerk, what can I do regarding, my lord, fake registration of students who are appearing in matriculation examination? Lord, if your lordships would kindly come to 2 documents which will make the position clear. Now, if your lordships would kindly come to page 59, this is a communication written by the principal of our school to the, my lord, inspector of schools. Please come to page 59. Second sentence from top. There are 8 number of feeder schools under Senga Higher Secondary School, namely so and so. All the students of the aforesaid school used to appear in HSLC examination, sitting in our school, higher secondary school, as the examination center. Each school has their own dice code. The principal of each school apply for registration of their own candidates. Higher secondary school. For the last 3-4 years, there are neither any student nor has any teacher of their own in Senga Girls High School. That the
dexterous headmaster of the Senga Girls High School, namely Samsul Haq, notwithstanding having not any student or teacher of their own, illegally using the dice code till today without surrendering the same. It is reportedly alleged that Said Samsul Haq, without justification, felicitate 30-40 number of students sit in pre-board examination at Sangha Higher Secondary School every year without providing any invigilator. In this regard, we brought it to the notice of the superior authority several times. Besides this, we furnished a written complaint in this regard before the Secretary Controller on 2/1/25. It is brought into light another fact that one Abdur Rauf Ahmed, this the Milord, the person who is running a private academy, is running to academy under the name of Diligent Academy Private School without having any dice code of his own, situated at Padmapara and Senga, and maintaining a secret nexus with Samsul Haq. Said Abdur Rauf is also managing some students and facilitate those students to appear in the high secondary examination in this year using the dice code of the Senga Girls High School. That, sir, it is to say that before commencement of the HSLC examination, the admit card along with photo attendance sheets and other examination related documents of all the students belonging to those feeder schools came from the office of the Inspector of School, Barpeta. In the wake of receiving of those particulars, we distributed all those admit cards, calling the headmaster of all feeder school. That it is mentioned hearing that a few days before commencement of the HSLC examination, the MD of the Diligent Academy came to my school and told me that some anomalies is occurred in respect of 9 number of admit card, and he has corrected the same and sought for my counter signature. But feeling some smell of rat, I did not put my signature therein. Accordingly, I deputed one, namely Elias Ali, that is the petitioner, LD of the school, to the office of the SEBA, that is secondary education, to verify the authenticity of the same. On arriving at the office of SEBA, when Elias Ali showed 9 number of admit card to the officer of SEBA, then the authority concerned wrote cancelled over all 9 number of admit cards therein. Xerox copy of so-and-so is tagged with the reply. After coming back from the office of, I declared an urgent meeting in our school on so-and-so. During the meet of the meeting, MD of the Diligent Academy, namely Abdur Rauf, gave a written undertaking that he would correct the anomalies appearing in the admit cards by roll number so-and-so, and given a written assurance that he would take shoulder of all the responsibilities for further anomalies if likely to happen for the same. That, sir, it is again brought to your kind notice that due to occurrence of some anomalies in the admit card, the guardian of the students along with some local created some chaos and hue and cry situation in our school campus. So, my lord, this is the modus operandi. This, the director of that private institute and Prince Headmaster of the Senga Girls High School, my lord, they are doing the mischief. And my lord, unless the Board of Secondary Education officials collude, is it possible for a clerk alone to do all this mischief, my lord? And my lord, I have been placed under suspension and I am suffering, my lord. So
But is it not a bit prima facie? We do not know at this stage. Is it not a preliminary stage? Investigation is going on.
No, my lord.
Show cause is given.
No, my lord.
If you have to
Actually,
be,
normally, my
if
lord.
you have no involvement, you'll be cleared.
No, my humble submission is, my lord. Prima facie, what is evident, that is what I am only placing before lordships. So even prima facie indicate my involvement. My lord, at times, my lord, we find that this power of suspension and all order exercised very, my lord, mechanically. My lord, lordship knows our manual of departmental instruction clearly stipulates that unless a major penalty is likely to be ensured, normally this suspension should not be resorted to. Now, my lord, the principal has not been touched. Official of SEBA has not been touched. The headmaster of the Senga High School has not been touched. There's one gentleman called Bhorali who deals with this registration. He has not been touched. Why I alone has been picked up? Lordship knows the decision of the Supreme Court in GC Sharma's case. If many people are involved in a racket, then you cannot just pick up one and impose punishment against it. If the basket stinks, you can't say there's only particular apple is stinking. But that being the position, my lord, my humble submission is, prima facie, there is nothing. Let them produce the records, my lord, on what basis the satisfaction was derived at that I should be placed under suspension. End of the day, my lord, the file would reflect how the satisfaction was arrived at, that I am guilty of misconduct, therefore it warrants a disciplinary proceeding, therefore pending trial of the disciplinary proceeding, I may be placed under suspension. That satisfaction must be placed before lordships, because affidavit filing may take a lot of time.
So therefore, let them produce and let them also file an affidavit.
And your lordship, pertaining to that, your lordship, one instruction has placed your lordship
Like what?
on 5/1/2026. On the last line, your lordship denoted that further a communication seeking detailed written explanation while later dated so and so has also your lordship placed your lordship and was also issued to the principal Senga HS School District. The written reply submitted by the principal has been received and the same is presently under examination. That letter is also under examination, your lordship. One letter has also issued to principal, your lordship. So your lordship, this matter, your lordship, show cause notice has issued upon the petitioner, your lordship.
So that's
You
all right.
will
Show
take
cause-
this, I am not challenging the DP, my lord, I am
That
not challenging. the
Time
DP.
will take its toll. See, show cause notice, this, that, everything will happen. What the petitioner is saying is that, why are you putting me under suspension?
Let-
Is there any material to show that I am involved?
Let
So
the
that
affidavit
you
be filed.
clarify, you get
Yes, your
instructions from that.
Yes, your
We are on
lordship. We'll
that.
be filing it, your
Because
lordship.
DP may go on and on, we don't know. How long
Yes,
is
your
it?
lordship.
Even I am not challenging the DP, my lord. My lord, my only humble submission is let them produce the file where the satisfaction regarding my involvement is recorded. No affidavit is required, my lord. Let them produce the file on 19th, my lord.
Please write, by filing this writ petition, the petitioner has challenged. The petitioner has questioned. The decision of the authority concerned to place him under suspension. And that as to whether there was any subjective satisfaction of the authority concerned, showing the involvement of the petitioner in the allegation or any materials whatsoever requiring him to be placed under suspension. Stop. Mr. K. N. Chaudhary, London Senior Counsel, has drawn the attention of this court to the reply submitted by the principal of the Chenga Higher Secondary School
To the inspector of
to
school.
the Inspector of Schools, BDC, Borpeta, wherein the principal, upon finding something wrong, in 9 numbers of admit cards, had deputed the petitioner to verify the authenticity of the same. Stop. It is only on that count that the name of the petitioner finds mention. And according to the learned senior counsel, that does not indicate the involvement of the petitioner in any manner in the allegation that have been made, requiring him to be placed under suspension. Stop. Next para. Ms. P. Das, Learned Planning Council, Secondary Education, on the other hand, submits that a show cause notice has already been issued to the petitioner and the department proceeding is on. Stop. Further, the principal of the that letter is what, principal? Reply from principal.
Yes, your lordship.
Apart from this.
Yes, your lordship.
Apart from this,
Yes, your lordship. Written submission, written
apart from the
reply has submitted.
apart from the communication dated 12/7/2025 of the principal of the school, the principal of the school has been further asked to submit. What was he given? A show cause?
Your lordship, a detailed written explanation, white letter number
Was asked to give a detailed written explanation,
E67.
and the reply has been received back by the inspector of schools.
Yes, your lordship, dated that
Which is under
explanation
examination.
letter was issued on dated 13/12/2025.
All right. Next para, be that as it may, since the petitioner
That
has
was
challenged
placed under examination.
his placement under suspension, being without any prima facie materials to show his involvement, the learned standing council, secondary education, shall obtain instructions by the next day and also produce the relevant records by
So we'll
which
be filing our affidavit.
uh, a decision had been arrived at to place the petition under suspension. You'll file affidavit, bring the records also.
Yes.
Yes,
You
your
might
lordship.
just pose
Yes,
it out
your
also. List again on so and so. When?
Would it be, my lord, the
February.
29th, my lord?
29, your lordship, February 29. Case matter, takes 2 days already.
Let it be, my lord, the 9th of February.
Yes, your lordship.
List on 9.
Deeply.
I'm deeply obliged.
This is one Paravas comments or something. You take it back. Ms. P. Das.
Instruction.
May I please, your lordship? My lord,
Sir.
my lord, here in this case, lordship, the petitioner was a principal in a higher secondary school. My lord, departmental proceeding was drawn against him on the allegation that he had sexually assaulted a minor girl student. My lord, in the departmental proceeding, I have been imposed penalty of compulsory retirement. Against that, statutory appeal was filed, and that appeal was, lordship, disposed of upholding the order of the departmental authority. My lord, against this repetition is filed, lordship. My lord, today, lordship, I am not bothering your lordship more. My humble submission is that, lordship, notice may be issued and they may be directed to file a affidavit, and records may call for in this case, considering the fact that the petitioner, lordship, had remained less than 2 years since service period. So notice and records.
That the
Record.
notice may go as.
In this
at
case,
this
lordship,
stage, your
records will be necessary.
Records for
Because
what?
there are in the departmental proceeding. Because, lordship, vital facts, basically 2 points that we have raised that have not been answered in the departmental authority in the impugn order nor in the appellate order.
Let the notice may go at this.
Why you are objecting in the records? Records will be necessary in this case because the hearing was conducted on several
Today is
days.
the first day.
And in the
The
order,
one,
lordship.
you cannot make a general statement that let the records come.
My lord,
You have to tell us
yes,
why records is necessary.
yes, lordship. That is why, lordship, I am saying.
Tell me.
My lord, on 2 days, lordship, hearing was conducted. One was in the year 2024 and another was in the year 2025. Details hearing along with the teaching staff through video conference that was made in the month of August 2024. That nothing was reflected, lordship, in the inquiry report as well as in the impugn order, none of the impugn orders. And only the, lordship, the facts, which was, lordship, a hearing was conducted in the year 2025.
Where have you stated that?
Yes, lordship, I have stated.
Paragraph?
Well, at page 13, para 23.
Read.
Your lordship may take the page 14.
Paragraph.
Para 23. And para 12 also, Lordship.
Paragraph?
Paragraph 12 also.
If it is not reflected in the inquiry report,
My lord, I have annexed that inquiry report, Lordship.
no, you have
This is the
annexed it.
vague inquiry report,
Please listen.
my lord.
If it is not reflected in the inquiry report or anywhere,
Nothing in.
now what will the record show?
My lord,
There will be nothing.
no, in the record, Lordship, as the hearing was taken place.
Hearing was taken through video conferencing.
Not only, no, I was present before the inquiry officer, and video conferencing was done, Lordship, in respect of the other teacher of the school.
Correct. Evidence was taken through video conferencing.
Yes, and their statement was recorded.
Statement was recorded.
And I also cross-examined them. Everything was on record.
You gave your signature on that?
So far, Lordship, I am not.
On your
aware.
cross-examination and
Yes,
all that?
I am, Lordship, duly cross-examined all the 5 teachers.
Sign.
The 5 teachers of the school. They were present in the incident, and they have stated through video conference. And I also cross-examined through video conference. All the statements and cross-examinations were recorded.
You were present physically.
I present physically.
Did you sign in the cross-examination?
Well, to that effect, I have
Then-
no instruction. But this was in terms of a notice, Lordship. Notice was there.
You're insisting upon the records.
Yes.
For what reason? This is what I fail to understand.
So, Lordship, so far inquiry is concerned.
Will you
There
issue
was-
notice at this
Yes.
stage, if so required, definitely we'll call for the records. Let us see first. Heard Mr. M. Khan, learned counsel for the petitioner, who submits that by filing this writ petition, the petitioner has challenged the order dated. What is the order dated?
My lord, order dated, inquiry report dated 22/5/2025, and orders imposing penalty 29/8/25. Lordship, page 43, 49 and 60.
Page?
43, inquiry report. We have challenged the inquiry report also. Impugn orders, 2 impugn orders, page 49 and 68.
What is the penalty? What is the penalty imposed? upon
Penalty
the-
compulsory retainment.
Has challenged the
Page 49.
inquiry report dated 22/4/2025, bracket annexure 10, comma,
Measure penalty of compulsory retirement.
measure penalty of compulsory retirement passed by order dated
29/8/2025.
29/8/2025, bracket annexure 12, and the rejection of his appeal by order dated
29/8/2000, 16/12/2020.
16/12/2025, bracket annexure 19.
Yes.
Issue notice of motion returnable by 4 weeks, Ms. B. Das. Standing Council Secondary Education accepts notice on behalf of respondent members,
1, 2, 3, and 4.
on behalf of all the respondents.
Yes.
Notice is complete. Petitioner to file, to furnish extra copies within 2 days. Respondents to file their counter affidavit on or before the next date. This again also it's
May I pray for a date? Lordship? There is no private respondent, Lordship. As the date may be.
Yes, 12, delay to 12 to.
what are you saying?
No, he wants a specific date, your lordship.
Oh.
Already
No,
given,
you
your
talk,
lordship.
you talk about some private respondent.
No private.
There's no private respondent.
Yes, your lordship.
Okay.
Deeply obliged.
May I please, your lordship? Here, my lord, petitioner before your lordship is the first wife of deceased, my lord Nizamuddin, who was subject teacher of Singmari Muhammad Ali, is school, my lord, who expired on 17/9/2023. Thereafter, my lord, petitioner being the first wife approached the authorities for family pension. In the meantime, she has come to know from the treasury office that the second wife of the deceased has withdrawn the area pension as well as my lord, family pension, monthly family pension up to December 2023. So against that, my lord, action, my lord, he has filed the first wife petitioner filed complaint before the treasury office, my lord.
First wife. Who withdrew? First wife.
First wife. Thereafter, treasury officer wrote a letter to the director of pension to.
Oh, just a minute. You
Well-
said first wife has withdrawn.
No, second wife withdrawn.
Oh, second wife.
Second wife
withdrawn.
withdrawn.
So first wife complained.
The first wife complaint, my lord. Thereafter, treasury officer wrote a letter to the director of pension. Accordingly, director of pension also wrote a letter to the inspector of school for inquiry into the matter. And thereafter, inspector of school entire matter heard and a report, inquiry report submitted on 31/2025. But nothing has been done as yet. Matter is pending. My lord. In between, my lord, the second wife also filed a my lord, a petition, which is second, my lord, petition against the order, against the my lord, letter of the my lord treasury officer.
Who is the first wife? Item 40.
Item 40 is the first wife. Second is the second wife. So in the second petition, my lord, I have been made party as respondent 6. I also appeared and also filed affidavit in opposition. In my first case, my lord, it has yet two times it has been sent for instruction. Notice has not been issued. So my lord, notice.
No, second wife has filed the
Second one.
second one. Why? Challenging what?
Challenging the treasury officer letter, my lord.
Letter means notice.
Notice. He has sent a letter to the director to clarify
Okay.
the matter.
Now,
After
what is the
complaint.
instruction of required?
So at this stage, my lord, in my first case, my lord, in my lord, notice may also be issued and fixed both matters for admission hearing. So that on that day, your lordship may dispose of the entire matter.
Yes. You are for the second wife.
No, Lordship, I am
For the bank.
appearing in for respondent of 5. Bank.
Oh, bank.
Yeah.
Okay. What is your say in this?
No, we are the disbursing authority.
So what do you say about this claim?
That is a dispute between the first wife and second wife, that the pension is being stopped by the treasurer, the director of pensions. We are
Okay.
still the disbursing authority.
You're only disbursing whatever direction comes, you disburse. And Yuri?
Lordship, I had a communication with the official, director official. So they confirmed me that steps have been taken, needs further 1 week's time. So your lordship may fix the matter after 2 weeks.
Steps have been taken for what?
For meeting the grievance, releasing of a pension. Because here, with the return, so as part of proposal that has been submitted by them, so needful action has been taken.
What proposal?
My lord, your lordship will find page 25, my lord.
Yep.
That is the inquiry report submitted by the inspector of schools after hearing both parties, my lord.
What does it say?
He has said, my lord, the last paragraph, my lord. The first, my lord, second, last but second one, my lord. The next of kin certificate shows that both the wives, both Jahanara Begum and my lord Afruza Khatun has been identified as wives of late Nizamuddin Ahmed, cannot be denied. The first marriage divorced and second marriage of Nizamuddin were held on the circumstances narrated above, that since the name of both the Jahanara Begum and Afruza Begum appeared in the wife in the next kin of certificate, your honor may be pleased to take suitable decision and pass necessary order as per order, as per my lord.
Page number?
Page number 25 and operative 26. 25. That is inquiry report submitted.
Inquiry done by inspector of schools.
Yes. Inspector of school.
Lordship may grant me 2 weeks' time, not to. As I'm going for seeking.
All because of not issuing notice, the matter is coming in motion.
Very full, sir. Steps to say, apart from this,
Please write down. The dispute here is in respect of grant of family pension
Wait, 135.
between the first wife and the second wife of the late government employee. Stop. The Inspector of Schools, NDC Nagaon, has submitted his inquiry report
Recently.
to the Director of Pensions on 31/2025, bracket NHIL, stating that a detailed hearing was conducted and that the parties were found to be included in the next of kin certificate issued by the competent authority,
Deputy Commissioner.
that is Deputy Commissioner Nagaon.
No.
Stop. Mr. B. Diori, learned government advocate, appearing for the official respondent, submits that he may be given 2 weeks' time to come up with the up-to-date status of the decision to be taken by the Director of Pensions. Next para, in view of above, issue notice of motion returnable by 2 weeks. Mr. B. Diori accepts notice on behalf of respondent numbers. One, two, respond number two. Two only.
Lordship, I'm for two.
While Ms. Pidas, learned standing counsel,
135.
secondary education notice on behalf of respondent numbers 1, 3, and 5.
For she.
Yes, RM Barwa, SC Finance, accept notice on behalf of respondent number 4 and 6.
For respondent number 5, item number 41. Both are checked together.
Anyone appearing for 7? No one.
Person.
7?
7.
Item 41, anyone appearing? 41.
41 item, respondent number 5.
Oh, petitioner.
Petitioner, yes. Name has been shown in the cause list, but.
Who is that? What to do? He's not appearing. Take steps. Steps on respondent number 7 by speed post within 3 days. List again on 6/2/2026, along with WPC number 2528 of 2025.
Will 252 be my present case, madam. 2528.
Yes,
Yes, yes.
it's correct only 252.
Yes.
Oh, this is already clubbed together.
Yes,
Already clubbed together. Mr. Your good name? KK Nandi, learned standing counsel. Which bank? State Bank of India accepts, appears on behalf of respondent number 5 in WPC number 2528 of 2025. Stop. Despite listing of. No, not required, despite the consent. Not only. Since they have not come, I'll not issue notice on the other one. What to do? Petitioner's counsel is not there,
Yes.
but it'll come together again. But it'll be in the motion column, isn't it? This will has to be in the motion column. What to do?
Date of February, fixed for look and date that you have very over.
2528, just see. So,
Isn't it? mid of February, my last part of February to close very good. তারপরে পাইয়ে দেবো আপনি।
Notice all these. List along with so and so, 258. It's okay. Notice already issued in that case. Should have told me. Wait. So what remains now? Next will be steps of. Okay.
You have to attend.
My lord, on 6-2. 6-2, my lord. 6-2, yes.
Yes, yes, sir. Yes, Lord. Yes.
Item 45 of the supply list.
My lord, one matter yesterday came up before your lordship, my lord, that regarding Pokrajhar University. This, yes, the other one, my lord, Bodoland University. Yes.
Taking the seat here, my lord. The counterpart is there, Borden University.
Yes, my lord. My lord, similarity is that, dissimilarity is only that he was initially appointed in another college, Janata College. Janata College, subsequently he was promoted to the post of principal. And thereafter, my lord, he was appointed, duly appointed. In fact, advertisement was issued and he participated in the advertisement and he was selected. And thereafter, he was appointed and he is on lien, my lord, for 5 years. So, my lord, for a period of 5 years or until his attaining the superannuation through due process. So, my lord, time to time lien was extended, and so lien, his, my lord, period was valid up to 31st May 2027.
There's nothing such like act and all that out here. involved.
Yes, Act is there, my lord. 2009, Bodoland University Act
What is that?
2009.
What is the provision?
Provision is that, my lord.
Relevant provision.
Yes, my lord, register has to be appointed, my lord. There is an, my lord, ordinance also. My lord, it complies with the, my lord, that act, one ordinance, some gazette notifications are there. As per that, my lord, register,
Where is the provision for appointment of registrar?
my lord, lordship will find that page 42. Page 42, section 12, my lord. Below. Yes. The register shall be whole-time salaried officer of the university. The term and condition of the service of register shall be such as may be prescribed by the ordinance. So, my lord, ordinance, as per ordinance, my lord, register shall be appointed by the executive council on the recommendation of the selection committee through advertisement as per UGC norms.
And how are you appointed?
Yes, my lord, advertise was issued.
Through advertisement?
Yes, through advertise. Advertise, lordship will find the advertise at page 22. Page 22 is the advertisement, my lord. Advertise was issued on 25/11/2021. for the post of register, one post, my lord, unreserved. And the lordship will find required qualification down below, lordship. It is written the post of register is a term post for a period of 5 years or attainment of 60 years age, whichever is earlier.
Okay, now where is
Now, lordship, kindly see the appointment letter.
page?
Page 23, my lord, Annex 2. Initially, his appointment was for a period, my lord, temporarily he was appointed for a period of probation, my lord, 1 year. Subsequently, my lord, it was he regularized, my lord. So, lordship, in second paragraph, my lord, lordship will see the appointment is purely temporary and terminable by giving in writing 1 month's notice on either sides. This is written in the appointment letter itself. And lordship,
This was for 1 year.
yes. And lordship,
Probation.
yes.
And has been confirmed
Yes, my lord.
or extended.
My lord, my time to time it is extended, and my lien has been extended up to my lord 31st May 2027.
Lien means what? You have been
Yes,
appointed.
I was initially appointed in a Janata College, and lordship will find I was appointed in the year 1991 in the Janata College as lecturer.
So your lien remains there.
Yes. And
Until now, you have not,
2000, my lord?
till the issuance of the impugn order, you have not been, your lien is still remains.
Yes, my lord.
Right?
And I have joined, my lord. In fact, I have joined in my submitted my joining report, although it is not approved till now, because my lord, I have been released.
Release.
I have been released. So if I not join, my lord, subsequent, my lord, consequential proceeding may be issued. That is why I have
You
submitted
have
my.
released, you have been released, you have joined, that you have admitted.
Yes.
So what is your prayer today?
Prayer, my lord, lordship will kindly see, my lord. Lordship, as per ordinance, my lord, removal of employees, my lord. There is a procedure for
For that
removal.
part only you are there.
Yes.
So for that
So, my
part,
lord,
you examine.
kindly
you
see,
should
my
not
lord.
notice.
Kindly see, my lord.
Hmm.
Annexure 32. Annexure 10, page 32. This is the letter issued by the, my lord, BTC secretary.
Yes.
So, my lord, with reference to the subject cited above.
This will be examined, Mr. Kalita.
Yes.
Because the other day we had the occasion to look at this aspect of the matter also.
Yes.
You are not on any interim order at this stage.
I am on, my lord.
You have been released, you have joined there.
Yes.
You go and join, things will happen.
My lord,
Now, insofar as the legality or otherwise of the removal of you from that post of registrar, that will be examined after once the other side responds to that.
yes.
If it has been wrongly done without any procedure, then court may
Without any
take
procedure,
a call on
and
that.
and my lord, out and out, this order, Annexure 13, page 35, my lord. This order is illegal because, my lord.
I know. See, today, as on today, you cannot pray for immediate setting aside of this order.
Yes.
Process has to go. So what I'm saying is that instead of going to all these details, ultimately the issue is that you have been ousted. Just like that, on the basis of some resolution taken by the, what do you call, the
BTC.
Executive Council.
No, my lord, it is BTC, not Executive Council. It is BTC. BTC has
Executive
no.
Council of the BTC.
Yes.
That's
Executive
what.
Council is a different.
There are two Executive Council, one university, one is BTC.
Yes.
This is BTC, I
This,
know.
this is BTC.
I referred to that only, BTC.
Yes.
So according to you, BTC Executive Council has no business in resolving that I should be removed.
Yes.
And who are they to act upon it? This is what you're questioning. That will be examined. All right.
Yeah, my submission only, my lord, that this order is stigmatic because this or foundation of this order is that the recommendation of the BTC, my lord. BTC has no role. So, my lord.
So only difference is that you have a place to join somewhere in Janata College. You have done so. Be there for the time being. We will see, we'll examine. We'll have a short notice and a date, and if they give a response, and we can finalize the matter. That much we can do today.
Yes, short notice, my lord. In that case, short notice, because my lord, it casts a slur on this my lord, like, career on his, my lord.
All right, Mr. N.K. Kolita. I'll not bother asking the learned senior counsel to submit, okay?
But
And issue notice only.
Only Lordship may just indicate. We are appearing on behalf of the Borderland University, 1 and
Yes.
3, my friend and me, 1 and 3, respondent 1 and 3.
Right. Mr. N.K. Kalita, learned counsel for the petitioner, who submits that the petitioner is aggrieved with the, where is the removal order?
My lord, page 35.
Is aggrieved with the office order dated 30/12/2025, in bracket annexure 13, by which the petitioner has been relieved from the post of registrar. Borderland University with immediate effect. And reverted back to his earlier post of principal of Janata College. Sarfan Guri,
Yes.
BTC. Stop the learned counsel submits that the reasons for issuance of such the impugn order is on account of the resolution adopted by the Executive Council of the Borderland Territorial Council in its meeting held on 9/12/2025, recommending removal of the petitioner along with the registrar of Kokrajhar University. Stop the learned counsel submits that the university,
My lord, he is from Borderland University.
sorry, Borderland University. No, the other one.
Yes.
I'm talking about the other one.
Yes.
There's no correction. This will remain as this. He submits that the Borderland University is the Borderland University was established
2009.
by the Borderland University Act 2009, which came into effect. What is the date of the notification?
My lord, 27th February 2009.
Huh? 27
27 to 2009.
27/2. How do you, from where do you say that?
My lord, it is first page, my lord. Lordship will find.
First page of what?
At my lord, page 36, my lord.
No, that is not the right one. Because there has to be an appointed date.
Assent was, my lord, received on 19 February.
It is not that also. Section 1, subsection 2 says that it shall come into force on the such date as the state government may notify. When is that notification?
28 February. 28 February.
Which came into effect?
28 February.
Which was to come into effect with effect from the date the state government notifies. Stop. The learned counsel submits that it is not in dispute that such a notification has since been issued. And the service conditions of the registrar and other staff of the university is governed by the said act. Stop, despite the same, on the basis of the resolution adopted by the Executive Council of the Bodoland Territorial Council, the petitioner has been illegally removed, illegally relieved from his post of registrar of the said university. Stop, having no alternative, the Learned Council submits that the petitioner has joined the Janata College in the meantime. Stop, he however submits that since the impugn action is illegal, same should be set aside. Next para, in view of above, issue notice of motion returnable by 4 weeks. Mr. KK Day, Learned Council accepts notice on behalf of the respondent numbers 1 and 3. While
Ardas for 4 and 5.
Ms. Ardas, Learned Council accepts notice on behalf of respondent numbers 4 and 5. Mr. S. Bhuya, Learned Standing Council, Higher Education Department accepts notice on behalf of respondent number 6. Steps to be taken for service of notice upon respondent number 2 and 7 by speed post within 3 days. Extra copies of the writ petition be furnished to the Learned Councils appearing for the respondents today within 2 days.
Kindly fix a date, my lord, because
list again on so and so.
Yes, please, that one, on the same issue.
Should it come on the same day?
No.
Not necessary.
Because
It's a bit. 10 February.
Oh.
Respondents to file their counter affidavit in the meantime so that the matter can be taken up for final disposal on the next day.
Okay. 10
February.
10 February.
Please ensure filing of affidavit so that we can take a call.
Apply.
Item 46, order no steps.
No one. No one appears for the petitioner when the matter is called. List again on so and so. Give a date.
For orders, item 33.
Next one was for payment of area as well as current salary. Area salary has been paid, but current salary amount like 5,33,000. 45,324 has not been released. Although the proposal has been placed before the Director of Education on 20th February 2024, and this is in the record also.
What is your instruction?
Madam, I am appearing on behalf of SMT 60 for respondent number 1, 5 and 6. And as per my information, my lord, the report from district has come and now it is under the process in the office of director, my lord.
2 years ago it has come.
No, my lord.
February 2024.
On 6/1/2026, and as per that letter, it is stated here that the report has already been sent to the director, my lord. So sometime may be granted so that further proceedings can be done.
Where is the order? Is it page 15?
Direction part of this,
Yes, direction of this court.
direction of this court, my lord, at page 15. Para 14. It is submitted at this stage, the directions will also be issued to the director secondary and image as school of the petitioner has been amalgamated. According director of education as well as director of secondary are directed to take steps in terms of the opposite direction. Steps taken in the 3 months. Prior to that, 13, my lord, considering the facts of the case, direction is hereby issued responded to consider case of petitioner for inclusion on name so and so, and thereafter pay his current salary. This part has not been paid. Further, the arrear salary October 17 shall also be considered arrear salary paid, current salary proposal, that is what proposal has been sent. So within 4 weeks, let them settle the issue because this proposal is mailed on February 2024. I mean the record I have placed it.
Madam, as for my letters, it is stated that
Non-royal certificate issued by the school, that is 5,45,000 in the month of February 2024 with regard to current salary.
Matter relates to payment of current salary.
Current salary. That part has not been complied with.
Current salary, is it quantified? How much is it?
It is a by law direction is there. Non-royal salary is 5,45,324. Certificate is there of the school.
Page?
Page, my lord, I have given in the record a loose sheet. Lordship, I am.
This is the problem. You see, you give loose sheet disappears.
Loose, my lord. This is in my, I can give it.
What is the amount?
5 lakh, that is the non-royal of next page, third page, my lord. Fourth page, non-royal of certificate. This is certified the area amount of 5,48,324 rupees. So with effect from 1/3/23 to 28 to 2003 in respect of person, the grade 4 employee of the school has not been.
This is
proven.
area salary.
That person, because the area and current, that is, this person has not been there. Not.
No, this is an area amount.
Yeah,
How do you say this is a current salary?
My lord, what happened, the total amount, they have released one part and another part they have, that is, they are saying the area salary. This much, it will be, if that is got, there is no contempt.
my lord,
Only this
as
person.
per headmaster, he has already taken the VRS on 31/1/2025, my lord.
So?
So there is no question arises regarding the current salary, my lord.
Then what about this certificate given by the headmistress?
My lord probably is not aware of the case. My brother is probably not aware of the case. Mr. Chisti is well aware. On that is what Mr. Chisti submitted, my lord, kindly consider the order of 6/8/2025. Pay bill submitted to the treasury. His submission was like that. একটু আসেন এক্সট্রা কপি কোর্টত দি দিলে হয় জুনৰ জানুৱাৰী
18/12/2000.
এইটো দি দিলে
Non-royal certificate was issued by the headmaster on 18/12/2025, my lord.
another same amount ne
Yes,
same amount
5,45,324 as arrear amount, my lord.
same amount.
Correct. That is the amount.
Yes.
So when are you paying that?
So my lord, sometime may be granted as the SMT 60 is also not here, my lord, because of he is not feeling well, so he has to leave the court, my lord. So
Some time was granted since 18/8/2025. Since 18 August last year, some time was granted. How much further time?
At least 2 weeks may be granted or so that
Sometime?
assembly system can take the up-to-date status, my lord. Here.
There was the order dated 18/8/2025, wherein it was recorded that Mr. SMT Chisti, Learned Standing Council, shall get up-to-date status regarding payment of arrears salary for the month of March 2023 to February 2024. Not month, for the period. For the period with effect from March 2023 to February 2024, amounting to rupees 545,324. Stop. The Learned Council, where Mr. SMT Jisti is said to have left the court early today, as he is not feeling well, as he was not feeling well. Considering the same, let the matter be listed again. When? On the opening?
20,
20,
28, my lord.
28th of January 2026, on which date the current status regarding payment of the said salary should be informed to the court. Mr. U. Sharma, Learned Counsel, appears on behalf of Mr. SMT Chisti and he has made the said submission. Right.
35.
That was 33.
May you please your lordship, matter may be taken after some time. Conducting counseling is on leg.
Who is there for the other side?
Chief, I am appearing here, and we have done our part also.
How?
In terms of the para 9 of the judgment.
What is that?
Para 9, if direction was there. Para 9, 10 and 11, lordship. To count the past service and give the benefit. Lordship, we have done that, and now the university and the AG, they are responsible for complying the rest of the part. Paragraph 9 of the judgment.
University.
No, I am for the respondent number 4.
No, now the university has to do something.
Yeah, university, not yes, university and the AG.
Which university?
This is Silchar, Assam University, lordship.
Anyone appearing? Are they a party here?
If I am appearing for respondent number 4.
How many respondents are there?
4.
Pomi Barua.
Yes, lordship, I am appearing for Pomi Barua.
What about the others? Vice Chancellor, Registrar, Principal?
Lordship.
No one appears. Till now. What is this IFO? Personal appearance. You have not taken press steps.
Lordship, let the conducting council become,
You're not engaged in this case.
no, Lordship.
You are not engaged in this case. Are you engaged or not?
Yes, Lord.
Are you there? What is your name?
M. Bora, Lordship, I am not, my senior is there, Lordship, SP Chaudhary.
You're M. Bora.
Lordship.
Your name is here, M. Bora. Is it not your duty to check the office notes and make your submission? Or you leave it to the court to do everything?
No, Lordship.
You have failed to take steps also. Director is there. He's appearing.
Correspondent number 4.
4. The rest, no one is appearing, and you are asked to take fresh steps as far back as on 4/6/2025. You have not done so. So how do we go ahead if person is not notified about this content? Take fresh steps. Mr. A.R. Taibildar, Learned Counsel, paying for respondent number 4. Submits that the respondent number 4 has done everything on his part to comply with the court's direction. How do you say that, Mr. Taibildar?
In terms of paragraph 9, 10 and 11 of the judgment.
No, what have you done? How you have done? You have shown
We
that.
have regularized the period. We have forwarded.
Document, affidavit, where? You will say like that verbally, and I'll say, okay.
I'll find it.
Then has complied with the court's direction. However, no such affidavit has been filed. Respondent number 4 to file affidavit within 2 weeks.
Not.
This court, by order dated had directed the petitioner to take fresh steps for service of notice upon respondent number 1 to 7 by registered post with AD. But the same has not been done. Stop. On the request of Ms. M. Bora, Learned Counsel for the petitioner, 7 days time is granted to take fresh steps upon the respondents except respondent number 4 by speed post. List again on so and so.
36.
May I please, your lordships?
Yes.
Last order, lordships, 18/12/2025. SM Chisti took time. My case will be placed before the DLC in the next meeting. And the judgment is dated 16/6/2023. Paragraph page 27, lordship, kindly see paragraphs 39 within 2 months. Illegally provincialized other person that has been set aside direct consider.
Is right, Mr. SM3 Chisti.
My lord, I am
The-
appearing here, my lord. My lord, in compliance to order dated 16/6/2023, my lord, the matter has been placed before the district scrutiny committee, and district scrutiny committee has not recommended the petitioner for provincialization, my lord. This is my order here, my lord.
Actually, submission is not correct because last occasion there is a direction to place afresh because wrong direction was placed and the officer instructed to place again.
The matter was placed, my lord, the 16/8/2025 before the district scrutiny committee.
You filed affidavit.
Yes, I will.
Who will appear, you or Mr. Chisti?
I am appearing for respondent number 2, my lord.
2. And Mr.
Yes.
Chisti?
And
Yeah.
Mr. Sisti is respondent number 1 and 3, my lord.
1 and 3.
They are
Yes.
changing the council and
No, no.
making submission.
No, he's,
No,
There
there
is
is,
a-
he's number 2.
Kindly see,
Chisti is 1 and 3.
yes. And I am for the respondent number 2.
on behalf of the Summa to last occasion, however, the inspector school culture has been again requested to place the matter of Saleh Begum Lashkar afresh again before the DSC for consideration in the light of above facts. That is, letter is dated 23/11/25.
Yes, my lord.
They have
and
provided to me.
accordingly, my lord, the matter has been placed before the district scrutiny committee on 16/8/2025.
So,
This letter is 23/11/2025, your letter. You provided to me.
22.
This one.
Oh,
Thereafter direction is given.
so sometime may be granted so that I can get the up-to-date status.
Mr. F. U. Borbuya, learned counsel for the petitioner is present. Mr. U. Sharma, learned counsel submits that he appears for respondent number 2.
Two, my lord.
And Mr. S.M. Chisti, learned counsel,
Respondent number 1 and 3.
appears for respondent numbers 1 and 3. He prays on his behalf as well as on behalf of Mr. S.M. Chisti for another 2 weeks' time to obtain up-to-date instructions and to file their show cause reply in the form of an affidavit. Prayers allowed. List again on so and so.
Vote to.
37.
Yes. No one. This is for orders. None appears for the petitioner when the matter is called. Of Lawazima Court's order dated 5/1/2026 indicates that AD card nor answer, neither AD card nor answer of notice has returned back from respondent number 7. And therefore, fresh notice has been recommended to be issued. Stop. However, since no one appears for a petitioner, matter stands adjourned to be listed again on so and so.
May I please, your lordship?
Affidavit has been filed, lordship, but not take with the record of the case, lordship.
When did you file?
Yesterday I have received
Already,
Let it be connected.
on January, lordships. Last week of January, lordship. Take up.
Ms. R.P. Bora, learned counsel for the respondent number 1 submits that an affidavit has been filed by the respondent number 1.
19 of the.
Stop. It is however seen that the same is not on record. Registry to verify and connect the same to the record and list the matter on
19/1.
30
30.
Lordship.
31/2026.
Oblige.
Deep level. 39.
There was a direction to appoint the petitioner, but then the.
Well, here, well, we have received a signed copy of the review petition. Well, by tomorrow we will file it, my lord.
Review.
My lord.
Well, in fact, on the last few occasions, they've been making the prayer, well.
By tomorrow we will file, my lord. We have, today we have received a signed copy. The petition, my lord, review petition, my lord.
So once you file the review petition, how long will it take for the matter to be listed?
Probably after Bihu vacation, matter may be listed before the.
No, unless you take steps, it will not be listed like that.
Well, we will take, my lord, we'll take necessary.
Because this filing has also been, of course, 3-4 occasions they've taken time to file it. Tomorrow they are saying they will be filing it, well.
Today we have received only the signed copy of the petition, my lord. By today, tomorrow we will file it.
Mr. P.K. Bora, learned counsel appearing for the respondent, submits that review petition is ready for filing and will be filing
By tomorrow, my lord.
the same by tomorrow. That is, give the date. Considering the same, let the matter be listed again on so and so.
Okay.
Obligement.
Item 48 of the subject is for others.
None appears for the petitioner on the matters called of the Lavasima Court's order dated 6/1/2026 indicates that notice has been delivered to the respondent number 7 on 29/11/2025 as per the postal track consignment report. Stop. In view of above, notice on respondent number 7 is accepted to be complete. Stop. Since no one appears for the petitioner or the respondent number 7, let the matter be listed again on so and so.
For admission item 20.
May I please refer? My lord, this matter pertains to non-provincialization of the school on the ground that petitioner school have not dice code, dice data.
You don't have, so how do you get provincialization?
I have already dice data. my lord.
You have the dice data.
Yes, my lord. Kindly see page the page 44, my lord. 43 also, 43 is relevant.
Any affidavit filed?
No,
Affidavit will be required. Otherwise, it's one side of the story only.
similar matter yesterday listed is directed to file affidavit.
Mr. Bora, you there?
My lord,
Elementary.
my lord, here basically, my
should
lord,
raise there.
SSA is the main party, my lord, they have to.
SSA party, main party. Mr. B. Sudhir.
Please write for proper adjudication of the matter. Affidavit is required from the respondent SSA as well as the elementary education department. As paid for on their behalf. Further, 3 weeks' time is granted to file the counter affidavit. Let the matter be listed
And I-
again on so and so.
And my lord, another matter fixed on 29th of January. Similar matter, yesterday already 29th of January.
29. What
Yes.
is the position?
19.
He still got some admission notice.
1/6. We put this similar matter.
Similar matter.
Ah.
Along with 6 WBC 6265. Both the matter, same matter.
Your case, it's your case.
Yes, yes.
Okay. No, it'll come on that date you pointed out. List the matter again on so and so. That date? 29/1.
29.
Obliged.
One more line, Mr. P.K. Bora, Learned Counsel, appears for the
Elementary.
Elementary Education Department.
21 and 22.
In this case, my lord, today we have filed our affidavit, my lord. Person?
You have filed.
My lord.
Have you received a copy? You want to file a reply?
No, already I have filed a, already I have filed a reply. Reply file good.
Reply. How can you file reply before they file counter affidavit?
Your Honor,
In anticipation of reply, counter affidavit, you file reply.
no, Your Honor.
Then
Previously, they have filed a communication. And against that, I have filed.
that communication is different. Counter affidavit is different. You want to file a response to that counter affidavit or not? If no, I'll record it and list it for admission hearing.
I will file,
If yes, I'll give you time.
okay,
Hmm?
I will file a reply.
Mr. P.K. Bora, Learned Counsel for the Elementary Education Department submits that counter affidavit has been filed on behalf of the State Department today.
My lord.
It is however seen that the same is not yet connected to the record. Stop registry to verify and connect the same to the record. Liberty is granted to the petitioner to file a response to the counter affidavit, if so advised, within 2 weeks. List again, so and so.
Obliged.
23.
May I please your lordship?
Yes.
Lordship, this is a case for illegally deprive the petitioner to getting the MXCPS benefit, my lord. But here today, my lord, they have filed an affidavit, my lord, just few minutes ago. My lord, I have received the copy, my lord. I need only 2 days time, my lord. Accordingly, matter may be fixed on
after reopening, my lord. And this is a very much simple matter, my lord. What happened? They have said, my lord, I have not completed the 10 years service, regular service, but I have been initially appointed on compensatory ground. And compensatory appointment is always regular basis, my lord, against the sanctioned vacant post. That is their mistake, my lord. That's why, my lord, I have been deprived. My lord, this was a small matter, my lord. That's why, my lord, matter may be taken up on 28.
Yes, yes.
28, my lord. In the meantime, my lord, I will file the reply, my lord.
Yes, Lord.
29, my lord, not 20.
As prayed for by the learned counsels for the parties, list again on 29th of February. 29th of, on? Okay, on 30 January, Friday.
Second February.
On 3/2.
3/2.
Yes.
On 3/2/2026.
Interim order pass earlier
Mhm.
said 40 November.
Parties are at liberty to exchange their pleadings in the meantime.
Yes.
Interim order passed earlier shall continue till the next date.
On 15/11. Oblige, your lord.
None appears for the petitioner. When the matter is called, list again after the ensuing Puja vacation, ensuing Bihu vacation.
25.
Lordship matter pertains to the non-payment of the post-retirement and the after retirement benefit, your lordship. No affidavit has been filed as yet, your lordship.
Who is the department? Which is the department?
Education department.
Education in which?
Secondary.
Secondary.
My lord, in this regard, we have received our instruction here, my lord, and actually allegation was, dear my lord, he has taken 1,500 rupees and which was apprehended by
Okay.
vigilance and
You file it?
yes, anti-corruption department.
File the counter affidavit then.
Yes.
Mr. U. Sharma, learned counsel appearing for the Secondary Education Department, submits that he has received the instructions and prays for 2 weeks' time to file the counter affidavit of the Secondary Education Department. Prayers aloud.
As a date may be fixed, your lord.
List again on soils.
Oblige.
26.
May I please, Lordship, item 24, Lordship.
24 is gone. 2. What did I say? 24. Give a date after Bihu on so and so, any date. 12/2.
Done with parents,
Sorry?
with parents, Lordship.
Non-appearance, I said. Okay. Then you cancel that as paid for. List again on 12/2. Okay.
Well, in this case, well, I have received the instruction, well, I want to file our affidavit.
By which time you'll file?
मतलब short date may be given, मतलब
After
provincialization
Bihu
matter
vacation, well, matter may be listed after Bihu vacation.
22nd or
By 19.
After Bihu vacation means it can be 19 also.
19, my lord, by 19 we will file it, my lord.
It can be December also. Which one?
December, no, January
Okay.
19, by January 19, I will file it, my lord.
then 22nd, my lord.
22nd?
Yes.
No, they listed on 27.
Yes.
What is the situation? Okay. Mr. P.K. Bora, Learned Standing Counsel, Elementary Education Department, submits that he has received the instructions and prays for 2 weeks' time to file the counter affidavit. Prayers allowed. List again on 27th of January 2026.
Oblige.
Item 27.
May I please? In this case, my lord, we have challenged the selection process, my lord. They have filed affidavit. Affidavit is totally silent, my lord, recurring our contention. They,
What is your contention?
they are not conducted, my lord, as per the advertisement, my lord. The recruitment process was not conducted, my lord, as per the advertisement.
Where is the specific environment
Lordship.
in the writ petition?
Our pair is state lordship.
Not prayer, specific government. That advertisement has provided for so and so, but they have not done so.
Lordship.
Where is it?
Paragraph 13 lordship.
Read,
Paragraph 13, page number 15.
please read.
The petitioner beg to state that further advertisement clearly stated that about preparing separate merit list, stream-wise, art, science, Hindi, Sanskrit in case of graduate teachers. Similarly, the SOP dated so-and-so made a provision that after completion of verification process, the zonal inspector of schools shall prepare a list of candidate who has been rejected, showing the ground for rejection against each rejected candidate and shall display it in the office notice board of the inspectorate, and shall also submit copy of the same to the director of the secondary education for publication of the same in the official website. However, in the instant case during verification process, although number of candidate was rejected for various reasons like not having qualification criteria on the last date of application, and secondly, for submitting of false certificate, against such rejection, till then no list has been published by the authority. These are one government. There are several also, my lord. They are
Since the pleading is completed, my lord, so my lord, let the matter come on admission hearing, my lord.
Immediately after vacation, your lordship may
Immediately
fix it.
after vacation.
On 28, your lordship.
So you have summed up your counter affidavit in one paragraph or in without any parawise reply.
Lords, no parawaz.
There's no parawise reply. And what about the specific government in paragraph number 13? How will you address that? This is what they're saying. You have gone beyond the advertisement or you have not complied with the advertisement.
My lord, this is filed through NJ Khatoniar, my lord. So, my lord.
Okay.
Yes.
Referring to paragraph number 13 of the writ petition, Mr. S. Bothakur, learned counsel for the petitioner, submits that the same has not been responded to by the respondent number 3 in her counter affidavit. But on the other hand, Mr. U. Sharma, learned standing counsel, secondary education department, submits that the matter is handled by Mr.
NJ Khatoniar.
NJ Khatoniar, who is not present today. Considering the same, let the matter be listed.
On 28, your lordship.
28.
28.
Third.
3-2.
We have to
Lords.
adjust
Understood.
so many cases in one
Lords.
day.
Deeply obliged.
Right.
29 and 30.
Well, in this case, they have also filed affidavit.
They have filed affidavit,
No.
not filed.
My lord, in this two matter, my lord, B. Kaushik informed me that he has filed the affidavit, but in the record also it is not here, my lord. So
No, my lord.
I have to
not receive any copy till that.
No, he also says that he is not there.
Yes.
Yes, madam.
So
So, madam, I have to confirm it through our clerk also, that whether it is filed or not.
who is appearing in this matter?
This matter was allotted to my lord, B. Kaushik. But my
Mr.
lord,
U.
it is
Sharma, learned counsel for the learned standing counsel, secondary education,
secondary education.
submits that the matter is handled by Mr. D. Kaushik, his
Yes.
colleague. And he has been informed that counter affidavit has been filed.
Yes.
He, however, submits that on checking the records, he finds that the counter affidavit has not yet is not available and prays for some time to verify the same from his office. Considering the same, let the matter be listed again.
On third, my lord. 3-2.
3-2. If counter affidavit is not filed, the same be filed by the next date.
Deeply obliged.
31.
This pertains to the university stoppage of the result of the students, your lordship. That regards to the students of the final semester of law, where their result was being withheld
for using two handwritings, your lordship. The other side was given the opportunity to file their reply on 2 occasions. It has not been filed yet.
Yes. Lordship, we have got instructions.
You are appearing for
I'm
which
on behalf of PG Pukul.
respondent number?
Standing Council, Guwahati University.
Guwahati University. What about the others?
I appear for the Bar Council of Assam, my lord. My lord, we actually have no role to play
Bar Council has no role.
because they have been, the results have not been declared by the university.
University.
And their grievance may be that they have not been able to appear in the AIB. But the appearance in AIB, the All India Bar Examination, that would be after they pass it or in the final year. But in any case, even if they appeared in the AIB, which was held in November, my lord, earlier it was, they have to take enrollment within 1 year. So earlier it was 6 months, now this time it has been made 1 year. So they may not be able to get enrollment if they did not appear in that AIB, since their results are not out.
So now this case is regarding withholding of the result, isn't it?
Yes, lordship.
Even if you succeed, then
Now, lordship, they have already lost a year. They could not, we have prayed for the interim at that occasion, but it was not being
no
possible.
interim not given.
Yes.
So now what is to be done?
So what we want is the result to be declared as soon as possible so that they do not get further loss in their career.
Yes, what do you say?
Lordship, my senior was supposed to appear and obtain, submit some certain instructions.
You're covering up for your senior, without any instruction. Didn't he tell you, do this, do that, say that to the court? Nothing.
He's suffering from heavy cough, your lordship.
Heavy cough. You cannot speak to each other.
Not yet.
He could not instruct you also.
Not exactly, your lordship.
So what do you want? What to do?
So, lordship, on the previous occasion also, the Dulumoni Das in case of petitioner number 3, they have said that the results will be declared on behalf of her. They have no any issues, but that is also not been done till date.
Anyway, counsel is not here. He has not been able to tell us anything. Except that he's having cough. What else do you want to say? What to do? Mr. PJ Phukan Lana, Standing Counsel, Guwahati University, representing the respondent, representing the State University. He said to be not feeling well. On a prayer made on his behalf, let the matter be listed again. Short date? When can he come? When will he come? When can he come?
Day after? Day after tomorrow, lordship.
Day after tomorrow?
Yes, sir.
Huh?
Day after tomorrow.
Not day after tomorrow. Let him come on after opening. Let's have a date. On 22/1/26. It's okay. I'm not marking you absent. You all are there. In the beginning, right, parties are represented by the respective councils.
In the meantime, they can file a reply, your lordship. They have not filed any reply also.
Okay, we will file.
On the next date, the Learned Standing Council, Guwahati University, shall come up with appropriate instructions with regard to the non-declaration of the results of the petitioner. And also file an affidavit in opposition. All right. Anything, Mr. Nair, you are there, let you remain as it is.
They clearly get the degree, that's.
Anyone may be made to dispose of the matter on that day, your lordship.
It's always there, Mr. Counsel. You come back, we'll see.
All right.
I have to rise. What to do? 32, anyone is waiting for 32? You will give you a date. Any urgency?
My lord, there is urgency because today the matter has been fixed for consideration of the interim order, my lord.
I see.
Lordship, instruction has not received, your lordship. After reopening of Bihu vacation.
What sort of interim?
My lord, one post may be kept vacant for graduate teacher science, my lord.
Teacher science.
Because there are vacancies that is very apparent from the advertisement itself, my lord. This. If your lordship have a look at page 29, my lord, the advertisement, my lord. Criteria for selection of graduate teacher, art, science, Hindi and Sanskrit. So
Let the affidavit. will
at
be
page
filed.
29, if your lordship have a look at that, the number of qualified candidates in the TETCOM recruitment test shall be in the ratio of 1:1 vacancies. The vacancy was 1:1 for the qualified candidates, and I am a qualified candidate, my lord.
Let the instruction be with
I-
me, your lordship.
I have secured more than the cutoff marks in both even unreserved category.
This is for the post of?
Graduate teacher science, my lord.
We'll do one thing, we'll give you a date.
Yes,
It's difficult today.
In this week, if possible, Friday, my lord.
your lordship, after vacation.
Friday, not
reopening
They do
of
not
the
have
vacation,
urgency.
your
I have
lordship.
the urgency, my lord.
Lordship, as soon as the reopening, your lordship date, your lordship may be given, your lordship.
What date can we give? 20.
If
Have it on
19
20.
possible, my lord.
20.
19.
20. Leave it on 20.
No, by the 20, I'll be out of it.
Then
19 per day.
Then your lordship 21.
My lord, 19, if possible,
21.
19, my lord. Immediate.
21.
19, my lord.
Okay, make it 19 then. You get
Okay.
instructions, whatever, we'll consider. We may not allow also, we don't know. You get instructions, whatever.
10 instruction, your lordship.
May it please, your lordship.
Much obliged, my lord.
Lordship, item 47, my lord, I am playing a date on 28.
You'll get a date. 20, item number
47.
47, as prayed for, list again on 3 February 26.
And
This is the only case. Okay, complete.
Acha. Podda is me ko.
Next item के दिया है।
Maybe.